with legal counsel.
Thank you, Madam Chair, members of the board. During the February meeting, a question arose concerning whether it was possible under the Practice Act and the Government Code for the board to recall and replace officers during the term of office. And since that time, I've had an opportunity to examine the pertinent code sections and case authorities, and I've come to the conclusion that because the Chiropractic Initiative Act requires the election of officers in January and effectively sets a term of office of 1 year from January to January, in the absence of a vacancy, the board cannot recall and replace officers. So there's no mechanism for the board to create a vacancy through recall. If there was a vacancy that occurred in an office, the board could in fact replace an officer because of the rule of necessity. Otherwise, there would be no one to fill that office. But in the absence of a vacancy, the board cannot recall and replace officers. And that was the conclusion I was able to reach after looking into the pertinent case authorities, primarily going back some time. And so that's an update on the discussion that took place at the February board meeting. I'd be happy to answer any questions or do any follow-up work on this issue if the board wishes.
Any board member comment? Questions? Any public comment? Okay, thank you, Ken.
Thank you very much. That concludes the legal briefing.
Thanks for the popcorn. Agenda item number 14, update, discussion, and possible action on licensing and continuing education committee meeting agenda. I know that you have materials in your packet, but they've been updated, so if you can get the materials out of the supplemental handout folder, they're more accurate. The first thing I want to talk about, just Dr. McLean isn't here. Dr. McLean is chair of this committee, and she left me with several comments that I will be including into my conversation on this. So again, Dr. Dionne McLean, she had to leave early. She's the chair of this committee, and I am the second member of this committee. We updated our strategic plan with proposed completion dates or completion dates for items that concern the committee, and the updated strategic plan is in your supplemental folder. You also have a list of the current continuing education requires, and then there are some items that we've been discussing as we're trying to rework the CE regulations that we want to bring to the board's attention, get feedback from the board and feedback from the public. And that handout was in your supplemental folder too. At the top it says proposed amendments to BCE's continuing education regulations. There's two items that we want to bring to the board's attention and get comment about. One is qualifying subject areas, we'll talk about that first, and the other is mandatory hours. So we have attempted to narrow our subject areas list to specific well-defined topics with the goal of licensee competence. If we're going to require CE, the main purpose of CE is to ensure that we have competent licensees practicing to protect the public, and our recommendations or things that we have talked about, it's not even a formal recommendation. These are subject areas that we feel are directly related to core competencies and patient care. There are 14 of them, and I would like to go through them with the board members first and get their comments about them, and then we'll have an opportunity for the public to comment on them as well. So this is important. Dr. McLean and I really want input, and so I'm going to go through these one by one and hopefully get some input from board members. So the first subject area is assessment procedures to include physical, orthopedic, and neurological testing. I think that one is pretty well defined. But
I'm sorry, Madam Chair.
Yeah.
I'm trying to find the document to follow you. Which one?
It's in the blue folder,
Oh, this one.
and on
Okay.
the top it says proposed amendments to BCE's continuing education regulations. Okay.
Got it. Thank you.
Question on that. Dr. Dane,
Yes,
why was diagnostics removed from there?
because we're trying to define the diagnostics. So if you have further definitions of what you would want procedures to be, then, or if you want us to leave diagnostics in there, that's fine too.
Well, I just think assessment and diagnostics are two different things, and so I don't,
That's why, Dr.
understand.
Arlena, that's why it was
I would
left in
agree.
strikeout, so that the board members could all see what was originally proposed and what the committee is considering taking out.
Yeah.
But these are policy decisions for the full board. so.
Right. So assessment and diagnostic procedures to include physical, orthopedic, and neurological testing.
I do believe, in light of the issue of current day with physicals, it would be wise to put in cardiovascular also, given that seems to be an issue of contention with, the insurance commissioner of California, that we're not trained to do so for high school physicals.
So clarify how that would read.
I would say assessment and diagnostic procedures to include physical examination, orthopedic, cardiovascular, and neurologic examination or testing. I think examination is broader than testing. Testing may imply utilizing some particular diagnostic procedure or methodology.
All right, so this is where we're at. I just want to repeat it. Assessment and diagnostic procedures to include physical, orthopedic, neurological, cardiovascular examination and testing.
Yeah, or just cardiovascular examination. Physical, orthopedic, neurologic, and cardiovascular examination. Yeah, I think
Okay.
just examination being
Got
broader.
it. You got it. Any other comments about number one? Okay, number two, radiology include diagnostic imaging and interpretation. Okay. Number three, interpretation of blood and urinalysis test results. Number four, evidence-based peer-reviewed clinical intervention.
I propose interventions, plural.
Sure. Number five, chiropractic adjustive techniques or chiropractic manipulation techniques as taught in Counsel of Chiropractic Education accredited colleges or formally recognized by CCE accredited colleges. Before we discuss this, I want to make one clarification because there's already been misinterpretation of this. I've gotten phone calls. This is not to be interpreted that technique has to be taught in a CCE school. It means that the technique that's going to qualify for an adjustive technique class is a technique that is taught in a CCE accredited school or recognized, meaning it's an elective or a club with a academic advisor. So,
I'm not a fan of that, just because I believe in an effort for us to be more contemporary, the schools are certainly not always the most contemporary with adjustive techniques, and so I know there's a lot of different adjustive techniques out there that are not accepted in the mainstream just yet.
I have a question related to that, because coming from the staff perspective, and we received the course, that's seeking approval, how do we determine whether the Azalino technique is something that the board would approve? We don't know what a good technique or a bad technique, and if it's something that somebody came up with. We just wanted a resource that's, I think staff was more driving this, is what we wanted to be able to refer to something if we were presented with something that isn't widely known. How would we determine whether it's something we should approve?
Well, do you currently have a list of all techniques
No.
approved in schools?
No, but if
they're
we
gonna get one.
had a list, it would have to be in regulations. So, but if we have some, and since it's an evolving, like there could be a new technique tomorrow, and it may be recognized by a school or by the chiropractic community in general. We need a resource.
I think one thing we can do, I'm just trying not to stifle or limit anybody if their technique is not accepted in a school. And certainly we know that there are too many different, and I don't have a technique, but thank you, Robert. I have not been that narcissistic yet, and I don't think, hasn't happened in 25 years, probably not going to happen. But nonetheless, I believe if that technique is being recognized by a school, it's a great idea. Being recognized by the CCE, how about being recognized by, any of the other accrediting bodies? There are specialty boards, for instance. I know in neurology we have specific manipulative techniques that have not been accredited by the schools, but yet they're widely known, accepted, and vetted in many specialty boards, accepted by the ACA, accepted by American Board of Chiropractic Specialties. And I know pediatrics has different adjustive techniques that are not being widely taught in the schools. And so I know we have some members of the schools here. Maybe you guys have some insight here, but I just think we need to have it a little broader, not to accept every single technique that comes through, but also not to stifle the people that are on the cutting edge that the schools have not adopted their techniques yet.
So,
That's
so
the challenge.
would you be comfortable if we said recognized by schools or chiropractic accrediting entities or
Absolutely.
accrediting boards? So okay, so if we so accrediting bodies that are recognized by the ACA and ICAC,
Or American Board of Chiropractic Specialties, that's overseeing, most specialty boards are overseen by that.
Okay, so CCE approved schools or specialty boards or accrediting boards recognized by the
American Board of Chiropractic Specialties.
American Board of Chiropractic Specialties. So do you think that would be sufficiently broad?
I think so, unless we have other opinions.
You can share those now since we're, yeah. It would help if you came up and spoke into the microphone.
Great. Hello again, I'll repeat, I'll tell you more about myself later. So would it be too broad?
Do you have your own
to simply-
technique?
Excuse me?
Do you have your own technique, first of all?
No, I do not. Would it be too broad to say that fall within the scope of practice? Techniques that fall within the scope of practice?
That's too vague.
That's too broad.
Yeah.
We struggle with that every day.
Yeah.
I'm sure you do.
Yeah.
I'm sure you do.
Yeah, just the scope of practice, determining what is the scope of practice is a debatable
Yeah.
topic. So
I think you may fall into the pitfall that you're gonna have a laundry list of all these things that it has to fall within in terms of accrediting bodies or schools, but then you don't have a list of all the techniques. So
But
that
We
would-
discussed this in our committee about getting lists of techniques from schools, not just California schools, but we're talking about schools across the country, of what techniques they are teaching in their curriculum, what elective techniques they have on campus, and starting with that. If something falls outside of that, which will likely happen but not be the majority of it, this will make staff's job much easier to have a list that will be updated on a regular basis. And if it falls out of that, then they can talk to, well, I'm not going to speak for Dixie, but they can talk to a consultant or someone who has licensee knowledge about the technique. So
yeah, if
Dixie,
I can just add, did you want to, because I just wanted to add to that we would, because if there are accrediting bodies or school, and so if somebody comes to us and says this is a technique that's recognized by the American Board of Chiropractic Neurology or by Palmer College in Davenport, Iowa, we can contact that entity and confirm that yes, this is a technique that we're familiar with. And
Sure.
So-
Does not the whole board vote on the CCE applications each time? it's left up just to the
So
executive
I think
office?
you're confused. There's two separate processes. There's the process to apply to be a CE provider, and there's the process of getting your course approved.
Got it.
So this would be more under getting your course approved rather than the being a CE provider.
And the approval of just the course, that's left up just to the executive office, not to the whole board?
Staff usually approves
Staff is the
classes.
one that does
If they have questions, they will ask a licensee or one of their experts.
Yeah, and this is the thing, because really it comes down to the law. What does the law say is acceptable for us to approve?
Sure.
And so, we want to be able to interpret the law as clearly as possible. And when there's ambiguity, then it becomes complicated.
And that's what you're trying to clear up
Yes,
with this?
yes.
Very good.
Dixie.
And the other thing that falls under this is,
would you introduce yourself?
oh, I'm sorry, I'm Dixie Van Allen, I'm the licensing and administration manager at the board. Pardon?
So you look familiar.
Oh. The other thing that happens under this category is that providers are claiming this course is an adjustive technique, when in fact, it's not a chiropractic manipulation or an adjustive technique. It may be physiotherapy, it may be rehab, it may be something else that doesn't fall under chiropractic manipulation technique. And so I think being more specific as to what it is we're looking for here will help me and help the providers more accurately define the subject area that it belongs under.
Yeah, my intention is not to be less restrictive or overly broad, but on the same level, we can't give 100% deference to the schools like they're the most contemporary, because they certainly are not. No offense to any of the schools.
That's what I was just going to say.
But they're not.
Lori.
I resent that. Yeah.
I know.
I'm Lori Eisenberg. I'm the Director of Continuing Education at Life Chiropractic College West. And just on this topic in particular, I want to suggest that in my school, and as I understand it, in most CCE colleges, any CE proposal that is brought to us about a technique is reviewed by the faculty, by the technique faculty. And so we discussed at the committee meeting the idea of it should be a course in the curriculum, it should be a club at the college, and I think those are great. It should be something approved by one of the major accrediting bodies, and that's great. But I also want to suggest that if we say approved by the faculty of a CCE college, all of the seminars that we offer, including some of the techniques that are not in the curriculum, I bring every single one to faculty members to vet. And so our faculty do, in fact, examine and approve any technique classes that we offer, whether or not those techniques are in the curriculum, or even whether or not they're in a club. So I want to put that out there to suggest that we take that into account.
No, that's very helpful.
I mean,
Take that into
if it's
account.
coming from a school, we would have to assume that it was recognized by the school.
Yeah.
Mhm.
And so, so that would be, those would be easy ones for us. Because if we're going to put in the law that it's CCE accredited school, so if we get a course application from a CCE accredited school in adjustive technique, we would most likely assume that
It's
that it is recognized
approved by that school.
Right.
Yeah,
Okay.
I'm
So-
comfortable with that. That's
Yeah.
very helpful.
Yeah.
If we can amend it to state such that it's approved by a chiropractic institution or postgraduate certification body, because I haven't seen thus far many postgraduate certification bodies approving many of these techniques that cause people to elevate 6 feet above the ground.
Right.
Can I just clarify one thing? We're not necessarily talking though about it being taught in the chiropractic college.
Right.
Correct.
We know that.
That's what the wording says.
Right,
present.
right. That's what we're
Present.
talking
That's what I'm
about.
trying to
Approved.
avoid.
We're going to work.
Yeah,
Wanna make
yeah.
sure that-
Yep. Great. Well, as long as we're taking public comment, let's just go back and get public comment on 1, 2, 3, and 4. If you guys have it, we'll just do public comment and board comment all at the same time. So, any public comment on the first 4? All right.
Thank you guys for your time. Appreciate being able to participate. My name is Eric McKillican. I'm a Sacramento chiropractor. I'm also faculty and staff at Life Chiropractic College West. The only thing I would add to what we were talking about with number 1 is in some type of, under the assessment, adding in the vertebral subluxation as part of, and not just strictly the physical, orthopedic, neurological, cardiovascular, but add in something to do with the detection and correction of the vertebral subluxation. That would be my suggestion for number 1.
I personally don't find that necessary because I think this is broad enough that it's encompassing of it. I understand the spirit of it.
Well, this limits it to very medical, whereas we as chiropractors also utilize our assessment in determining subluxation.
But in your opinion, so kind of what you're saying, in your opinion, the detection and correction of a vertebral subluxation is not an inherent part of a patient's physical, neurological, or orthopedic exam?
Well, there's other components to it as well.
What components may we be able to add in here, though, for it to be very tangible? Remember, once again, we're trying to make this more tangible for staff,
So,
whereas I would argue that as a chiropractic board, we would certainly encompass, or the vertebral subluxation is encompassed in physical and orthopedic.
Yeah, and
testing.
just which may help is because we're coming from a perspective of chiropractic, so we're going to assume something like that is part of this because these are examples, and so that's why there's a need to specify things that may not be assumed.
Right.
And
So there's a 5-component model introducing kinesiopathology, altered structure, altered function, neuropathology, obviously that's under neurology, histopathology, swelling, pathophysiology.
When, I'm sorry, I don't want to interrupt you, Eric, just,
No, no.
but
it's-
I guess,
I
to me,
guess-
that would be part of the physical exam of a patient.
Right, but you're identifying physical exam as being orthopedic, neurological, cardiovascular.
No, physical
No,
is a separate component.
Physical
Physical,
exam,
comma.
orthopedic,
Okay.
neurologic, cardiovascular.
Okay.
Yeah.
That's fine.
I mean, I think we're all on the same page. It's, I think what you're talking about is inherent in what a chiropractor is doing with their physical exam.
Okay.
Yeah.
Okay, I would like to see it in language. I would like to see us not moving away from, but towards the idea that we use the word subluxation within our stuff, so.
Problem is, when we get into that, it becomes very esoteric on many fronts where it makes it challenging because plenty of people argue they're assessing a subluxation by more than 5 means that you just mentioned.
Right. There are different-
And so that's where it becomes a logistic problem for staff. And so these are very tangible things that I think it's very easy for them to understand if the course is testing, and by no means are we writing out the subluxation in any of the code or being dismissive of it.
Okay. All right, thank you.
I just want to, just in general, and not specific to this topic, but your comments, like if you feel strongly about something, I just want to let the audience and the public know, if you feel strongly about something, and this is just the beginning of this regulatory process, and once the board finalizes the language, then we start the formal process, and that's quite a ways out, and then there'll be an opportunity for public comment, both in person and written. So if there's something that you would encourage the board to include, and then they don't, because it's their prerogative, you can certainly formally submit yours, and we will respond to that through the process. And I just want to thank all of the representatives who are here today from the profession and from the providers, because it really helps with this process to be able to hammer these things out at this point, rather than wait until we formally notice something and then start getting these things that, and oftentimes the board will say, oh yeah, I agree, we should address that. So
Awesome.
thank you, everyone.
Awesome. And then on number 5, if we were there, I was just going to concur with what Dr. Azzolino said and Dr. Pete was saying. Thank you.
Yeah, thank you. Any other public comment about number 1 through number 5? Yeah, Lori? Go ahead, because it may help us with consideration of the rest of the items.
Eisenberg again. So first of all, I'm really pleased about this process. I've appreciated being part of the public that attends the committee meetings, and I'm glad to be able to have this conversation. We talked about this at the last CE committee meeting, and it's about the intention of the continuing education that we certify here through the board. I'm a lifelong educator, and I come to Life West with that, with that background. And we talked about protecting the public. That's the goal of this board, right? Is to protect the public. And continuing education, we could go to kind of the lowest common denominator and say the purpose of continuing education is to provide minimum competencies to protect the public. And that's what we talked about on Friday. Minimum competencies to protect the public. I have to respectfully disagree with that. Continuing education in a profession is more than that level. We're shooting for excellence. We want to develop the chiropractors beyond their degree. We want to go further. We want chiropractors to learn new techniques. We want them to advance. We want them to incorporate from whatever valid sources they can new information. So I would urge us to think beyond minimum competencies and how can we protect the public by making the best chiropractors, having California chiropractors be the best they can be. And let's not keep it at that low minimum
I just, as somebody who's been a part of this department for about 25 years, and I respect and I agree with what you're saying. One of the word you used is "we want," and I think we all want that. We all want everybody to be way up here. But what the law authorizes us and requires us to do is establish and enforce minimum competencies, and so we can't force every member of the profession to be the best person in the profession, or we can't mandate that, but we can ensure that they all maintain their competency. So I don't want to debate or disagree with you on that. It's just that we do have limitations in what we ultimately can do, because when we submit this to the Office of Administrative Law, when we get to that final stage, they're going to come back and say, what's the necessity for requiring a chiropractor to do this, and we may not be able to substantiate it.
And Lori, I think we are trying to provide in these subject areas, especially with number 4, an area for growth, for things that we may not be able to foresee now as something, but that is developing, that is a new idea, that is something that will have room to grow into. So we're trying to be specific to number 1, eliminate abuses that we've seen in the process, and number 2, to make sure that continuing education is about protecting the public and making chiropractors safe and competent. But I don't, like Robert said, we all want chiropractors to be the best that we can be. And we would hope that chiropractors want to be the best chiropractor they can be. And we will help by allowing some, some proactive thinking on the board. And we can't see everything that's coming down the pike, but that's part of what we're trying to do with this as well. Yeah.
I just want to thank you, because it's extremely refreshing to hear that coming from the schools. And I do believe that if we're doing our job, as much as the law may dictate what minimal level of competency is right now, if we're doing our job and staying contemporary with modern day science, then that minimal level of competency needs to be moving. And I think that's where there may be some disagreement in our profession, and that is what was minimal level of competency in 1922 when that beautiful document was written, coming up on its 100th year of celebration soon. Is not what minimal level of competency was 5 years ago, and nor is it what it is today, and it better not be what it's going to be 3, 4, 5 years from now. So you have my commitment here to make sure we're going to keep pushing the needle.
Great.
Because those numbers should not be continually going down, as we see.
Thank you. I have another general comment, which is, and this is very much a from the trenches administrative point of view, and Robert and I just discussed this in the break. I would really encourage us, as we move forward with this important work of updating the categories and the regulations, to also consider updating the fee structure. California is the only state in the United States, and I know because I work with every state, it is the only state that requires providers to apply, to submit an individual application for each topic that is represented in a single class or seminar or conference. If you have a 3-day conference, if you're really following the rules and if principles of practice is eliminated, you could spend up to $1,000 if you honestly classified each session in that conference with the appropriate topic. And so I would love it if we could just, as we move forward with this process, and I think we are also maybe simultaneously moving forward with a fee, examining the fee structure.
Your comment is something that we've heard from many providers.
Mm-hmm.
It's not applicable to what we're talking about on our agenda item right now, but it is something that will be discussed at a committee meeting later on, and we have some ideas on maybe some different options to go with that. But yeah, it will be discussed.
Great.
Yeah.
Great. And my third comment is for something that's not in here. So it's about philosophy, and I know that my colleagues will have more and more sophisticated things to say than I do about it. But I'd just like to say that that is a very important topic in our school, and it's foundational to the rest of chiropractic from the perspective of Life West, and I hope that there can be some way to include, even in a limited basis, some form of philosophy in these standards. Even if it's more tightly defined or limited, I would hate to see it lost altogether.
Yeah. We had a discussion about that on Friday at our committee meeting, thanks to you. And I want to leave that to the end of when we talk about these 14 subject areas, because there's some information I would like to task you guys with. So let's leave the philosophy discussion until we get through these 14, because it is something that we planned on talking about here. Okay?
Thank you.
Okay, let's move on to number 6. This, I'm going to just point out real quick, in your folder, you should have the existing regulation. And all of my pages got messed up, so I need to find mine, but you may want to refer back to it when we talk about this. So number 6 has physical medicine modalities and therapeutic procedures. One policy discussion that came up in our committee is, do we want to call it physiotherapy as it is called now, or do we want to call it something else with a more appropriate description of this subject area? So that's something that we would like to discuss with the board and with the public. I will tell you, one of the comments that Dr. McLean, who's chair of this committee, left me was her opinion is to leave number 6 as physiotherapy like it's currently written. That's why I wanted you to have access to the current regulations, but something that we should probably discuss. So any board member comment about number 6? And I guess the question is, should it be changed to something that reads, thank you, physical medicine modalities and therapeutic procedures, or do you want it to just stay as physiotherapy? Because right now it's a one word, it's just physiotherapy.
And I think the challenge with physiotherapy lies is, can somebody give an accurate definition of it?
Yeah. I mean,
Nobody seems to understand it, even within our own profession. There's arguments over what it truly means. So I would move away towards a word that requires you to be an expert in chiropractic to define.
so right now, physiotherapy modalities, we could specifically define them, but that's going to put it in a box and not leave room for expansion or excellence, as Lori likes to say. So that's the discussion we want to have with the whole board. How do we deal with physiotherapy? And it is something that we're licensed to do. I think it's something that chiropractors need continuing education and updates on. if you learned it in school 25 years ago, it's not the same thing as it was then. So how do we regulate that in these subject matters? That's the question at hand. Marcus, did you have?
Marcus McArthur, Assistant Executive Officer of the Board. I have a question for legal. In regard to physiotherapy as defined, I just have a question about, and a question for the board also. So, physical therapy, in their law, it says that physiotherapy is solely in the domain of a physical therapist. I'm just telling you, like, that's what it says in their law. And so, in light of this conversation, is that something that, if it's defined, and whether or not we agree with their law, is that something that maybe, if possible, we move away from? If we can, if what physiotherapy is can be defined another way.
Before you answer that, I just want to remind everybody that it's also in our law. Physiotherapy is specifically in our scope of practice, so I don't know that another board can put something in law that takes that domain.
Physiotherapy,
But
are you sure?
it's in 302, yes.
Yeah, so the legislature can, within the restrictions, because we're dealing with an initiative act,
Yeah.
the legislature can change the law that affects our board or other boards, but another board through its regulations cannot directly affect the jurisdiction of this board.
Just want to be clear. Cool. Thank you.
Do you have the definition handy? Of how it's written in 302?
Physiotherapy?
Yes.
It's not defined. It's just stated as part of the scope of practice. It's just as ambiguous there.
My only concern with it is, as we've dealt with before, when the medical board comes before us and they question the use of laser, most of us would all agree that laser falls under physiotherapy. And yet there may be some other accrediting body out there that looks at the use of laser and defines it differently. And then we get caught into, does it fall within our scope or not? I think we would all broadly define most non-pharmaceutical, non-surgical interventions as physiotherapy. And those fall within our jurisdiction, but I want to make sure we're not cornering ourselves and letting a more powerful body out there define the use of a certain modality.
That's an interesting point, and Marcus and I have had long discussions about some of these. Excuse me. So there's because up above we have chiropractic adjustive technique and chiropractic manipulation, which are readily understood by the profession and lay people to be chiropractic. Chiropractors, there's a lot of other things in the scope of practice that a member of the public may not realize. And so I would think that number 6 should cover anything that is within the scope of practice, a procedure that a chiropractor can do. They should be able to get training on it. And so it would go beyond physiotherapy.
That's why we changed it to physical medicine modalities and therapeutic procedures. So a modality, something you do to a patient, a therapeutic procedure, something that the patient does or you do with the patient, is more inclusive, I think, than just physiotherapy, which would just include modalities, and is more associated with some of maybe the older modalities than the newer ones. And I think that's different than what we're trying to say here, and I just don't know if we're saying it in the right way.
My recommendation would be to include them all. Physical. Okay, so that's my concern. So I would define them all. I would state them all. Say physical medicine modalities, physiotherapy, and therapeutic procedures.
Just combine
And just
it all.
why give any ground? Do you guys have any comment on that?
I would want it, because back to something you stated earlier, Dr. Eslino, about the lasers. I think we put that issue to rest when we adopted our laser regulation. Oh, I'm
sorry. Dr. Azzolino had mentioned lasers, and I don't think there's any doubt anymore about the authority for the chiropractic profession to use lasers, because we did adopt a regulation with standards for the use of lasers. So we formally recognized it in our law, and it was approved by Office of Administrative Law to authorize that. But I would like 6 to be worded so that it's clear that we would approve a course on laser therapy, and these are the things staff who aren't chiropractors need to know if they get a course that's on some modality that isn't adjustive technique or isn't like laser therapy. They'd probably know, but are there modalities or techniques that a chiropractor would use that that aren't universally understood, that we would want this to be worded so that if we get the course on that, we would know that, oh, that's covered under number 6.
I think that's going to continue to be challenging, especially with new things that come up. And it just may be one of these subject areas where you get a lot of the same things that you understand and know, and then the things that are outside of that area you have to ask an expert on. I don't think we're going to be able to get rid of all of that problem that staff is having, but we're certainly trying to minimize it as much as possible. So I want things to be broad, but not so broad that staff doesn't know what to do. Occasionally, you're going to have to ask experts on it.
Yeah, I understand. Yeah, so this, but I just want to make sure that this covers all of that. So if we do have to consult with an expert to find out, is this in the scope of practice, or is this something that the chiropractic profession currently utilizes, just make sure that it would be covered under this category.
I think the category is fairly broad. Opinions? You think the category is broad enough to allow for things that are happening now or could be coming up, but not so broad that it'll allow everything but the kitchen sink in? That's really what we're looking at. So right now, the recommendation is that physiotherapy, physical medicine modalities, and therapeutic procedures is the way the recommendations are. Okay? Yes, please.
So I'll repeat again, and my question is, because Frank hasn't asked a question in the last 40 minutes, I feel like I need to. So my question is, how are you presently categorizing the cold laser therapy? Is that physical medicine? Is that physiotherapy? How are you guys categorizing that now?
We have separate regulation for that.
Just for, and it's named laser?
Yeah.
Okay, thank you. That's my question.
Actually, I think that may not have been an accurate answer to your question. So I'm not sure. We have a regulation for lasers that just talk about lasers, what you can, well, some of what you can do with them, definitely what you can't do with them. I think, and correct me if I'm wrong, was your question, how are we dealing with lasers in CE right now?
No.
No, you were, how are we
My
dealing with
question
it
was
with our
more
regs?
broad, just
Okay, yeah, it is in our
how
regs.
is laser isn't categorized as physical medicine or physiotherapy presently, it's just categorized
As lasers.
Okay,
Okay, good. I just want to make sure we answered your question
That was my
correctly.
only question.
Okay.
Thank you.
And I need to apologize and clarify, because I was, when we were referring to 6, I forgot that we also have number 4, which is evidence-based, peer-reviewed clinical intervention. So I think that's where, and I don't know, actually, this is where I need an expert opinion, is do we need to have these 2 separate categories? What would fall in one and not the other? Or, like,
Unfortunately,
would
you
number
could
4
say that
cover
just-
number 6?
You could say everything technically could fall into number 4,
Well,
But-
it needs to be peer reviewed,
but
not evidence-based, which very few things are.
well, I'm saying that a lot of the things that we're talking about could fall into number 4. but I think it's easier if we do separate out some things so that there is a more appropriate category for it to go in than for everything to try to go into number 4.
Okay, yeah, I just wanted to,
So I do think we need it as a separate.
To the discussion we had earlier, Robert, which is certainly going to be coming down the pipe for better or for worse, is the use of CBDs.
Yeah.
Yeah.
And should the day come where that's, evidence-based and peer-reviewed, it's not going to fall into any of these other categories and may fall into nutrition. Who knows? We really don't know, but certainly the peer-reviewed, evidence-based clinical interventions is fairly broad, and I think it has some benefit to being so. CBDs. CBDs.
marijuana
Cannabis.
products.
There's a trend in
Pot.
California. There's a trend in California right now.
If there's no more comment about number 6, we'll move on to number 7. The recommendation is current issues in public health. I think it's important to deal, especially now that we're talking about opioids. That would certainly be considered a current issue in public health. Instead of just calling it public health or communicable diseases, current issues in public health, I think, is more appropriate. So, any comments on that? Dixie?
Still believe this may be a little broad.
Which one?
Current
Public health.
issues in public health.
It is, but
Well,
I think
I
we
can
need to add
see-
some defining words after that.
I mean, not to include or,
Yeah.
yeah. And so what kind of, so as
I don't like that.
as the person who looks at all of this stuff, what do you foresee coming in here that we would need to, what kind of things?
Off the top of my head,
Uh-huh.
I don't really know, but I can just imagine having the conversation that pretty much everything under the sun can be related back to public health.
stress, anxiety, toxins,
Right, so,
Religion.
aliens.
You know.
right, so I think it's an important category, although we're gonna talk again about something that's coming up is, special population care. So I don't know if opioid management could be under special population care. But I'm not sure everything that would be in current issues in public health would fall under special population care. It might. So that's something to take into consideration. I don't know how to limit this category. I can certainly see your point of view and the flow of stuff that comes in at you. I just don't know how to, I don't know the wording to clarify that. Usually the best thing to do is have some examples about what might come through and say not to include, which you'll see further in this list of some things that are abused a lot. So if you can come up with some ideas, that might be helpful. Lori?
I just thought I'd toss in a couple positive examples of public health that I'd like you to keep in mind. We'll talk about epidemiology and success rates of different health approaches. And to me, that's always been classified under public health, for lack of a better place. So epidemiology is public health, in a sense. Also, diversity, both in terms of communication with patients and how to approach different kinds of patients. I've been putting that under public health, for lack of a better category. I don't know if it's special populations because it's kind of vague, but I think diversity is something that we all should be encouraged to teach in our classes. So those are two I just wanted to mention as important and that come up frequently in my classes.
I feel Dixie's angst there because, I mean, someone's going to argue that we're being overrun by aliens and that falls into public health. So I don't know how to define it any better. If you guys have any ideas, otherwise I think we're going to have to trust that, give you some leeway that you're going to be able to look on a case-by-case basis and look at their itinerary.
Marcus?
And I'd just like to concur and say that we currently have a subject area in law for public health. So if we're seeing it now, and it's not that big of a deal, I don't think that changing it to current issues in public health are going to substantially change what people are submitting to us.
Certainly not.
So,
But I would welcome some examples, Dixie, that might help us with this category to make it a little easier for you down the road.
I just think with the elimination of some of the other broad categories.
Uh-huh. Okay. We'll bring it back to committee and try to define that a little bit better. Let me just make some notes here, I'm sorry. Okay, we're gonna move on to number 8, nutrition. I understand that's a broad category as well, but nutrition is a broad category, so. Any board member comments about nutrition? Any public comments about nutrition? Dixie, any red flags about nutrition that you see? No? Okay. Hold on, I need to refer back to Dr. McLean's notes. Number 9. No. So now we're on number 9, special population care. The way we have it worded right now, which shall include but not be limited to geriatric, pediatric, HIV, and transgender care is related to the practice of chiropractic. Instruction in this subject area must be directly related to patient care. So some discussions we had in our committee and policy discussions here for the board is the necessity of including the option of courses in special populations. I will tell you that Dr. McLean's input on number 9 is to delete special populations altogether or to leave it as it was previously written in our other regs, which is, I just had it here. And now I can't find it.
No, but she's looking, she wants the old regulation.
want the old-
Let me,
Regulation. I don't know why I'm having such a hard time keeping these.
just a sec, I have them up on
straight.
my phone, I'll find it.
Absolutely. Yep, I just wanted to make sure that Dr. McLean's,
I don't,
okay, yep.
yeah, I recommend striking special population care because I think that stigmatizes a lot of things, especially with an HIV patient or a transgender patient. There is nothing we need to do differently in chiropractic. Certainly HIV, it's stigmatizing the HIV patient. If we're concerned about communicable diseases, it's not just HIV, it's hepatitis. I mean, the list goes on. So I think that's poor for us to do that. Secondarily, with the transgender care, there's nothing we need to do different in caring for a transgender patient. Nothing we need to do different treating any person of that entire community. I think some sensitivity training could be very helpful. I'm in San Francisco, I deal with this all the time. I just dealt with it yesterday with, an intern from West Virginia, not knowing how to approach that. And I said, you approach it very directly and you ask, how would you like to be addressed? And that's a sensitivity issue. I don't think it's a special care issue. And I think just even categorizing that as such sends a wrong message. So I believe if we're dealing with a patient population that requires some different physiological approaches, if we're dealing with a diabetic patient or something of the sort, now we may have to have a little more in-depth understanding of their pathophysiology, but certainly for transgender care, we don't need to do anything different whatsoever with those patients.
So right now, just because I found it in the current regs, instruction, special care populations, it reads now, instruction in the aspects of special population care, including but not limited to geriatric, pediatric, and athletic care is related to the practice of chiropractic. I think that we don't know what we don't know about some of the special population patients that we have. I have run into you don't know what you don't know about some of my transgender patients and some special populations. So I think it's an example of being proactive. I think it's something that's going to be more on chiropractors' radar, and I think it shows a board that is trying to be contemporary. I didn't read it as all as being, offensive to people with special populations. I saw it trying to be more sensitive to people with special populations and being able to give them care. So.
I think just the term special population, and I
So
made this
we can
phone
change
call
that.
2 hours ago to a transgender individual that is a chiropractor that I've encouraged to apply for this board, and I encouraged to come up here and give her opinion, because she took exception, as I do, with just even defining it as special, because we're classifying that person. That person should be treated, in my opinion, as a person. And if they have a gender issue, their gender issue is no more different than mine or Marcus's or any of us here. So anyway, that's my 2 cents on that. I believe if we're dealing with a physiological issue that needs to be treated differently, it's one thing. I mean, I think we need to have some sensitivity training. I think, when I started practice, we were told not to treat HIV patients during office hours. I never adhered to that, and certainly nowadays that we'd be chastised for even suggesting such. But in dealing with an HIV person, I mean, who's safer to deal with that, or somebody that has hepatitis B, or someone that has leprosy, or I mean, we could go down the list, and it's going to be a history lesson on what we've done with people that have communicable diseases.
Lori, did you have some comment? Yeah.
I've been involved extensively with the trans community and with diversity issues, and I have to respectfully disagree with your approach. And I think it's very, very important that as medical professionals, healthcare professionals, that we understand the differences in treating trans people, but in addressing diversity across all different populations. And I don't think it's punitive or isolating or demeaning to define people as different. You know what I'm saying. That it need not be demeaning to say straight up, we want to learn about how to do our best for this community, be it the athletic community, the trans community, or anyone else. So I just feel like I had to say that, because I think there are physical differences in people's bodies, and we need to acknowledge that. And someone who's trans does not carry the same body with the same issues.
How does that change what we do treatment-wise to them?
If you treat someone as a cis male who was born female,
What are you going to do different?
you may not be doing the right things. Their frame
How?
is different, their organs are different, their hormones are different, right? Than a man. Isn't there a difference?
Yeah,
between
and I
men?
don't want to debate the issue with you, but as a chiropractor, I don't see how you would be doing anything different. Certainly their pelvis may be formed differently, but as a chiropractor, you're going to be palpating and addressing things. But let me ask you, should we label treating Muslim women as a special community?
If there's something substantially different, then I think we should.
There is something
We could
substantially
teach-
different.
we could teach
Physiologically,
courses on
there's
that.
not.
We
Well,
could,
that's
and that would be
sensitivity training.
helpful for chiropractors.
Okay.
But I don't need to get into the minutia. I just wanted to kind of put it on the record that I feel differently, and everyone's
Okay.
entitled to their
Yeah.
opinion.
And
Thank you.
certainly the intention of this is what you pointed out. The intention is to give the best care possible. And I do think I do think that there are differences. There are things that you see on X-ray that might not be explained if the patient isn't forthright with you about their gender status.
I think we all want the same thing here, but I'm still struggling, having been in practice 25 years, having treated a lot of transgender people, what I'm going to see different on X-ray. Can you guys help me out with this? Because I may be missing something. Any of the chiropractors in the community? What are we going to see or do differently with that patient? Well, am I on trial here? Yes, I do. Yes, I do. Yes, I do.
Aren't we trying to define how we handle this
Yes.
in relation to CE?
Yes.
Yes, and I'm trying to not stigmatize any group of people, whether they have HIV or anything, by calling them special, because certainly when it comes from a sensitivity perspective, I think you have to have a far greater level of sensitivity in dealing with a Muslim woman as a male than you do with a transgender individual. And these are all things that I strive to teach each and every one of my residents. And, you know, I'm fortunate. We have a Muslim woman in the office. We have an Indian woman in the office. We've had transgender doctors in the office, and it's just everybody. And this is, you know, a question that I've posed to that community. So I think it would help us before we assume that they want to be labeled as transgender to actually hear from that community.
So right now, I am asking for the opinion of the board members. Two questions. Number one, should this be a subject area that is deleted from the topics? Should we keep it as it's written? And if so, should we change the wording of special population care? Or should we just eliminate it altogether?
Personally, I think we should have a category for sensitivity training. And I think it's very timely in this day and age. Because we do have a lot of practitioners out there that are a bit far removed from, and certainly I think there's, given some of our petitions of how they're dealing with.
I can get on board with that.
Yeah.
Should it be called sensitivity training? Should we just have a category called diversity?
Diversity, cross-cultural differences, because, you know.
I think we're all after the same thing, but want to make sure that it's done the right way.
And placed in the right place.
Yeah, well, to de-emphasize, because I share where I support this category wholeheartedly. I do see where somebody might be offended by the term special population, and so definitely that's something that we would want to rethink. But I like the idea of training in treating diverse populations, and I don't think we should give examples, but because then you could go nuts. But yeah, it's and we probably have to wordsmith that, but because this is where are we, number 9?
Number 9.
And yeah, so something to the effect of training in the care of diverse populations,
Or as Dr. Eslino suggested, diversity, sensitivity training, and cross-cultural awareness.
Yeah, well, it's, and I'm not a board member, so but I just is this related to patient care and ensuring that if you're treating somebody from a particular population that you're aware of certain things that you might want to know, or is this about being sensitive to, it's like, I would think that would be incorporated in it, but ultimately it's about patient care.
It is about patient care, but I think it's part of patient care, because if your patient isn't finding someone that they're comfortable with, or goes and has a bad experience in a chiropractor's office because they're not sensitive to their needs, then that's going to be a problem as well. So I do think it relates to patient care.
Let me give you a real life example, because this has happened in my office where I've had Muslim women, and I certainly have always asked of them and of their husbands if they're comfortable me examining them. And that's with my hands on their spine and doing orthopedic and neurologic examinations. And I've caught a lady that she ended up passing, unfortunately, of a carcinoma, and it was in her abdomen. Not for one second did I actually lift up her gown, even though she was wearing shorts, and put a stethoscope on her abdomen. I assumed that I had approval for neurologic examination and all the rest, and I had a female come in the office and do that examination. It was only after she said, "I need you to look at this here," and they knew that we were onto something, that they were okay with it. That does relate to specific patient care. It does relate to specific documentation of maybe someone that doesn't have a female in the office will say, "I've deferred doing this examination because of this ethnicity," or whatever it may be. And I think it's important for chiropractors to just be aware of that stuff, because it could go the wrong way very quickly if somebody's not keen to that stuff. So
My only concern would be just thinking of how, if this did become law, so the provider may not address transgender patients or Muslim female patients, and so if we're requiring this, or well, actually it wouldn't be required, but if we have this category, we don't necessarily know that it's going to address these type of things. If we're not somewhat specific, then it won't necessarily accomplish the goal.
Well, I don't think we're defining what they have to address. I'm suggesting that if one of these people here that provides continuing education is taking good notes, right, on writing a course right now, and they present it to the board and say, we want to cover these topics, current day topics on how to treat these populations, whether this says transgender, whether it says Muslim women or not, we should approve it if it's of substantive value to how a chiropractor would treat somebody. But, I mean, as you know, we could go on forever about this.
Yeah. So
We
I
need
don't
to,
want to belabor.
Any more board member comment about number 9? And I want to ask for public comment.
Yeah, Frank, you not being a board member, not being a chiropractor, I think it would be helpful to give us your outside opinion on this. I shouldn't say outside, but non-professional opinion.
Public.
Non-chiropractor opinion.
I'm listening attentively.
Well, I tell you what, I will bring the information back to the committee and we can wordsmith on number 9 more based on diversity and come back with some language for the board to discuss further.
And if you would like, I'm happy to reach out to some members of that community and see if they could weigh in on this opinion.
I would love it.
Because the person I spoke to very specifically said, I don't like all of this special attention and all the rest.
I can absolutely understand that, which is why
It's like I like to be a member of the
having
community,
the
not
discussion,
special.
why we're having the discussion and why we still think it's important, maybe not for
Mhm.
that patient, but for other patients to have
Sure.
this. So number 10, accurate and effective record keeping, which includes proper and ethical billing and coding, documentation of evaluation, treatment, and progress of a patient. This is not to include practice building or patient recruitment, retention, or business techniques or principles that teach concepts to increase patient visits or patient fees per case, or courses primarily focused on billing and coding. You can tell by the definition of this that it's a problem area. We want to encourage proper record keeping, and part of proper record keeping is billing and coding. But we're seeing, and correct me if I'm wrong, Dixie, a lot of classes that deal with how to bill, how to collect more money, how to do all kinds of things that are not necessarily related to patient care. We think it's important to have accurate and effective record keeping in here because we see a lot of problems on the disciplinary end with it. So we tried to define this as much as possible to get rid of some of the problems that we're having with it, and we welcome comments.
How about adding something about the SOAP note, literally in here about using the written SOAP note, and then maybe proper EMR notes, because we see a lot of EMR notes that are the same day after day after day.
So
Which is-
in addition to accurate and effective record keeping, you want
Right,
to specify
specifically,
electronic medical records and proper SOAP notes.
Isn't that pretty much defined in effective record keeping?
Well, it's
yeah,
actually
but
not.
but
It's
it's not.
That's what I'm sorry to interrupt, but were you done?
No, it's not. That's
Yeah, because our law on record keeping doesn't specifically, because I'm wearing my enforcement hat now, doesn't specifically say that you have to use SOAP notes. And so in enforcement cases, we get pushback on that. If our expert says that these records, the record keeping wasn't appropriate because they didn't do proper documentation, they didn't use SOAP notes, we get pushback on that. So I I think probably where we need to clean it up is in that law. We need to address that among other laws. But
Yeah, we need to.
but yeah, it's I mean, it wouldn't hurt if the course did encourage soap notes.
Okay.
But-
We can work on adding that into the language.
I think the rest of it's well written.
Any other board member comment? Any public comment about number 10? Let's move to number 11, ethics and law, including but not limited to truth in advertising, professional boundaries, mandatory reporting requirements for child abuse / neglect, elder abuse, neglect, and spousal or cohabitant abuse, neglect, and review of the specific laws, rules, and regulations related to the practice of chiropractic in the state of California.
The way this is written, my understanding is we don't have mandatory reporting for spousal or cohabitant abuse or neglect. Is that?
We don't have it in our law, but the overarching law does apply to chiropractors. So
For
you're
mandatory reporting for
mandatory reporting. So because there's laws in the is it welfare? I'm not sure what codes are in.
Institutions
Yeah, well-
Code and the penal code.
And the penal code that address who are mandatory reporters, and chiropractors are among the.
Okay, but what I'm saying is that's a category right there that could be very dangerous for chiropractors. Certainly I could see the child abuse and neglect, and I could see the elderly abuse, and certainly we should offer all assistance available to a spousal and cohabitant, but making that a mandatory reporting would mean that we could circumvent the relationship there and actually go report to a law enforcement agency. And if we're not specifically defined to do that for spousal, I mean, we have a HIPAA issue there also.
That's a concern, and I probably for any mandatory reporter, the
Child
concern,
abuse, we have to though.
and you, was it you or Becky, Dixie? I think it may have been Becky. We researched this and we came up with a cheat sheet that identifies all of the laws that are applicable to chiropractic, and so they are, whether chiropractors know it or not, they are mandatory reporters, and I think it would probably be good for them to be aware of that and know what their obligations
Okay.
are. And it is.
My question is, I know
touchy
we're
area.
mandatory reporters, but for all three of those categories,
Yes.
we are.
Yes.
Okay. And what's the medical board's stance on this here? Do we know?
What about it?
On all three of those categories?
That I don't know.
We should probably figure that out. I think
What
we
do
should
you mean? What's
probably-
their stance on it?
Well, my concern is child abuse and elderly abuse, hands down. I mean, elderly abuse, you could argue that the person may not be cognitively aware. Child abuse, they're under 18. We have a responsibility, but spousal cohabitant, I mean, if we're defined as mandatory reporters for that, I'm 100% in support of that. If we're not, I think we need to vet that with law enforcement and look at what the other boards are doing, because we can't get ourselves in trouble if a spouse comes in and the doctor's going to contact law enforcement and say, well, she's being abused or he's being abused without that patient's consent. Family court's going to have a field day with this one. And so I think we need to make sure we vet this appropriately with other agencies and with law enforcement before we step and cross that line with a HIPAA violation and all the rest.
I have some information that I think will clear up. I
Okay.
can forward it to you too.
Yeah.
Okay.
Well, give me your opinion on this. I mean, I just haven't looked at this at all.
There's a whole list of California's domestic violence and mandatory reporting law. There's a bunch of what we're mandated to do
Okay.
and what we're not mandated to do. So,
Okay.
and I understand your concern about domestic violence.
I'm just not
reporting.
educated on this.
Yeah,
I'm certainly, if I'm not, I would assume many of us are not, and it would be very helpful.
And that's one of the reasons why we want to include it as a qualifying subject areas, because it is a gray area. And one of the reasons I know it is because someone else asked me about it being on the board. So, Dixie.
One of the items that I thought about under ethics and law is, I believe we had talked about, I get a lot of applications that are about, let's say HIPAA or other laws, workers' comp, things that are under ethics and law that aren't necessarily under our jurisdiction, yet we are reviewing these applications and approving them. And wouldn't it be better for it to accept to accept CE for chiropractors taking those, but those courses should be given through that entity, not approved by us, given by whomever, because who are we to judge the, who are we to evaluate that person's competence and whether or not the materials that they're presenting are actually accurate.
I'm confused
So-
at what you're asking.
Yeah.
So like workers' comp, we get a whole course on, let's say, ethics and law for workers' comp, understanding the laws, how to testify, how to prepare a report, and it's all under ethics and law. But should that be something that we approve? As the Board of Chiropractic Examiners, we allow CE credit to be given to chiropractors for taking courses that are given by the Department of Industrial Relations. And likewise, HIPAA laws. I don't know that Joe Smith presenting, me as a layperson, and I'm not familiar with all the HIPAA laws. I don't know that Joe Smith is providing.
I have a question for you. You may not recall, but do you frequently see ethics and law courses offered by non-attorneys?
Yes.
Oh, yes.
So, okay.
Yes,
So,
I'd say it's about half and half.
yeah, so that's, if the person was an attorney or even a chiropractor, we would probably assume they have background or expertise in the area. It's hard for us to know if they're not.
But that goes across the board for everything.
True.
And I would hope that that's self-selecting. I mean, if people are taking a course and the individual's handing out bad information, hopefully that's going to come forward. But I mean, you really don't know with a physical exam course. You don't know if they're teaching appropriate technique. I think we need to have some auditing. And
Well, I think what her point is that we're the Board of Chiropractic Examiners, so we're not experts on workers' comp law or on HIPAA necessarily. And so even if we were to audit that course, would we know whether all the information was accurate? Would somebody need to have expertise or demonstrated expertise in those areas in order for us to approve the course, or should we just
I would hope that whoever audits it has particular expertise or becomes an expert fairly quickly. I mean, the same goes for pretty much everything.
Well, for workers' comp, we already allow the CE credit for any courses given by the Department of Industrial Relations. Wouldn't they be the expert in providing?
Yeah, but I don't think we should
That?
preclude our chiropractors from teaching work comp.
And I believe that your issues with, testifying or doing depositions for work comp, I believe this would give you enough teeth to deny that portion of it. And I'm just confused what kind of ethics in workers' comp are different than ethics for regular.
well, it's
chiropractic.
probably
It's
more
the
the
law.
law.
Okay.
Not the ethics part, but it's lumped as ethics and law. And so they categorize it under that subject area, ethics and law.
What would you propose?
I would propose that that people can get CE credit for those types of courses, that we would accept that, but we aren't the ones to approve those types of courses.
So you would say QME / work comp courses are accepted if approved through the Department of Industrial Relations or the DWC.
And I don't know what their, and somebody in the audience what their accreditation process is like. For the QME, yes, but just regular work comp. So the challenge lies in that regard. I mean, I would love to see all chiropractors that deal with and this is just a, cloud thought here, be at the level of a QME if they're rendering care to a work comp patient. I know that's not realistic. And the challenge lies if we preclude chiropractors from teaching work comp, then we end up having a lot of chiropractors out there that are taking care of work comp patients that are actually rendering poor decisions on the case that can hurt the patient. So I don't think we should restrict work comp education. I think if anything, we should make it more prevalent.
Do you think that if that was written into our regulation, it's going to preclude chiropractors from teaching work comp?
I don't know if an ordinary chiropractor that just is teaching work comp stuff that's not teaching at a QME level will be able to get approved by the DWC.
I think there's a broader issue here regarding, because we authorize or we grant CE credit for courses that are taken by any other health board approved provider. So a provider that's approved by the physical therapy board or the medical board or the nursing board will accept that approval and grant credit to our licensees. So, I mean, the question is, if somebody were to take a course that that's outside of our area of expertise, like, because by virtue of that, somebody who wants to take a course on related to surgery, could take one from that's approved by the medical board, and we would grant credit for that. But we're not otherwise approving surgical courses because it's not related to chiropractic. And so something that's as specific as workers' comp or HIPAA or HIPAA may I don't know that there would be any approved courses out there on HIPAA, or that there's an entity that approves HIPAA courses. Is there? Oh, yeah. See, so we would potentially preclude the colleges, but something like workers' comp, I could see where it's like we will grant credit if somebody is works in the workers' comp arena and they want to get training. We will grant credit for that. But should we be approving workers' comp courses? That's and this may carry over into other subject areas. But so we may want to table this and discuss it at the committee level.
Just so I know things to bring up in the committee, your concern is that if we aren't granting credit for workers' comp stuff, that the stuff approved through the DWC may not include chiropractic instruction. So one of the things that we would need to look at in our committee is to look at the choices through the DWC and see how many chiropractic choices there are, how many people that are teaching DWC classes are chiropractors.
Lori, do
Yes,
you,
that's
do you teach
true.
DWC? Or
And
Yes.
to answer your question, Robert, do I think we should be approving work comp classes? My answer is yes. I do believe we should because it's within our scope of practice. Surgery is not within our scope of practice.
Yeah.
And so I do believe
That
we
was-
should, but I do think we need to vet that a bit more. And, once again, I think we could look at that. An overarching thing that I'd like to say is that if, once again, we have an institution that's already vetted these courses, we have to have some deference to these accrediting bodies, whether it's a school that their faculty has approved it. I mean, we should have something in our regulations that says we can then rubber stamp that because Life West or Palmer West or their faculty has approved it. Regardless, if it's work comp, we know that it's being done at a particular level. Because I would hope that the school's not going to put something out that's not, valid.
So your suggestion is to possibly add to our new regulations for some kind of automatic approval for classes given by schools. I just want to make sure
I think that would be valid, and before we codify that, I'd certainly like to make sure that the schools have an appropriate vetting procedure, but I would think that if it's being taught by a postgraduate institution, or, in the past, if a postgraduate continuing education department in one of the schools was approving things, and there's really oftentimes little reason why the board should not.
Okay.
And just to be clear, so if I were to receive an application about workers' comp from just ABC provider, what would be my basis for
Canceling
denial
it,
or
bad name.
It depends upon what's in the the class content. If, like you said, it's about depositions and court testify, that doesn't have anything to do with patient care, so that would give you something to deny it on. But if it's about workers' comp,
Yeah, well, and we're speaking hypotheticals here, which makes it a little more complicated. But if you have an example of a course that we could present to the committee, and we can redact it, but a course that was submitted for approval, like in workers' comp for ethics and law, and we have questions regarding how good is that course, or how qualified is the instructor. I think that would be good for us to present to the committee and say, how would we address this? How would we ensure that this course was appropriate?
any other comment about number 11? Eric?
Thank you. Actually, it's in number 10, number 11, and number 12.
Okay. Can we keep to 10 and 11 right now?
It's going to include 12,
Okay.
just in the question that I have.
Okay. Oh, okay. I got it. All right.
Those three already fall under ethics and law. So the question is, as I look down into the mandatory hours, why are we breaking them up into 2, 2, and 2, which is now every year a 6-hour program that a chiropractor is going to have to sit through? And I want to preface, I have no problem with accurate record keeping. I have no problem with sexual boundaries, ethics and law. I think we all should learn that. But why are we going to 6?
Because we think that all three of these, I'm going to give the committee's opinion on this, not the other board members because they haven't commented yet. But these are 3 areas that we see as ongoing problems. And when you just say ethics and law, then you can have a 4-hour class in anything you want in ethics and law. And we want people to specifically get training in record keeping, and we want people to specifically get training in the chiropractic regulations, and we want people to get specific training in sexual boundaries. And that wasn't happening before.
Okay.
And under the law, you could have a 6-hour course, ethics and law course that we'd have to make sure that we had the wording right, but where if it was specified that 2 hours were in this, 2 hours were in this, 2 hours were in this, we could somehow, like where they don't have to necessarily take 3 separate courses, where this, yeah, it could all be combined into one. So that's one of the things that that we can look at if these do overlap, and they would likely be presented at the same.
Okay. Am I incorrect in looking at this and saying that every year, if this passes, I then need to sit through 6 hours of each of these topics on a regular basis?
Yes.
That you are interpreting that correct.
Okay.
One thing that I want to caution you about saying is if this passes. So this is a document that's a work in progress. You can already tell we're talking about it. We're going to take it back to a committee. But yes, as it stands right now, we think, and we're going to get board members' opinion about this, we think it's important for you to have 2 hours in record keeping, 2 hours in ethics and law, and 2 hours in sexual boundaries. Because we see a lot of disciplinary actions in these 3 things.
I don't doubt that you see a lot of disciplinary actions in those 3 things. My challenge is going to be, as an ethical practicing chiropractor, now having to sit through 6 hours of the same thing every single year. That's going to be my challenge, is looking at this going, what did I do wrong, and why do I need, when I go through my ethics and law.
That's well taken.
If I can give you an example, as civil servants and board members included, every other year we have to take sexual harassment prevention training. We have to take ethics training every year. So it's just required. And from a business standpoint, it's a liability issue if the state doesn't require us to do this, and then one of us violates one of these laws, then the state or our department could be held liable because they didn't do a good job of training and making sure. And it's because I'm a pretty ethical guy, and I'm familiar with the ethics laws and stuff. But every time I take it, it's like, I'll get a question or two wrong, and I'll think, oh, I didn't realize that, or so, and so you do. It is a good idea because I think a lot of the enforcement we see for sexual misconduct, for instance, oftentimes the provider is adamant, the licensee is adamant that I didn't do anything wrong. This is perfectly acceptable, and they weren't aware that what they were doing wasn't acceptable, and
Okay. So you made a point that it's every 2 years, which I'm going to come back to. I think this is excessive for a chiropractor who is not being punished. I think we're on the and I take the courses through Life West. I have to do them all. It's not a big deal other than looking at this going, what did we do wrong in order to? I think we could handle this in a more condensed version. Other than 6 hours,
it's not necessarily what you did wrong. It's just that we're here for consumer protection. We need to ensure, and since we do see a lot of violations in these areas, we need to ensure that every chiropractor is aware of the law in these areas. And so we're not saying that you did anything wrong, but we do know that there's a lot of misunderstanding or just lack of knowledge in these areas, and so to protect consumers, we're not able to go out and individually test each licensee, and so
I completely understand that. Yeah. And since this is a just an informative session, I'm here trying to give
I appreciate
my
that.
side of it, which is that's excessive. I mean, to me, it's excessive.
I would agree that if we're mandated to do this every 2 years, and we spoke about this, I think if we could actually adopt the program that DCA is making us do for all of the licensees across the board, not just chiropractors, but in medicine, we're going to have a much better, state out there, period. But I don't think we need to do it every year. A year goes by quickly.
The problem, I'm sorry.
But I mean, for our x-ray license, we have to do it every 2 years. There's a lot of things that we have to do every 2 years. Or my proposal would be to reduce that to 1 hour. I don't see why we should be mandating licensees to do it more than we actually have to per state regulation. But I do think, on the other hand, I do agree that record keeping and ethics and law has to be done every year. Because if you just sit through many of our hearings, unfortunately, we're here to protect the public, and unfortunately, these are things that are common violations each and every year. So
not in a disagreement with that. Thank you.
One of the complications we have is that for the vast majority of boards, their licensees renew every 2 years. We renew every year. So if we were on a 2-year renewal cycle, then it would be, although the requirement may be more.
So maybe something we can bring back to the committee is 1 hour every year instead of 2 hours every 2 years. I don't know how long that sexual harassment training that we have to do every 2 years. It's like
it's 2 hours.
Yeah.
It's 2 hours.
Yeah. And then they do mandatory years.
But,
so like every few years we have to do it.
But I also think we should change the topic of not just sexual boundaries. 2 hours. Geez, I mean, if people need 2 hours of that, they need to be institutionalized, in my opinion. So I think sexual harassment or harassment training or whatever our program is called through DCA is appropriate, because that covers far more than just an inappropriate sexual relationship. It covers harassment, and I do think that will have great value to practitioners in just dealing with their staff and dealing with harassment issues in the office. I could tell you that most chiropractors that I've spoken to about this don't have discrimination policies in their office, and it's a big no-no, and chiropractors need to know that in this day and age. If someone is discriminated upon in your office, you as the office owner is responsible, especially if you don't have a discrimination policy. So I think we should add that in there rather than just being sexual boundaries.
Well, while we have the board members and representatives from the providers, I'm curious if we couldn't amend 11 to say ethics and law, which shall include 1 hour in sexual boundaries, at least 1 hour in accurate, effective record keeping or something, or maybe we want to keep record keeping separate. But sexual boundaries and maybe we could say that the ethics and law course has to include at least 1 hour in sexual boundaries.
Yeah, I'm a little uneasy with the sexual boundaries because,
or whatever you want to term it,
unless
but-
you have an issue there, you don't need to be told to not have, to have healthy sexual boundaries. You need to be, no, that's a much broader topic of harassment,
Well, yes,
sensitivity,
well,
and the
that's
whole
why,
issue.
well, that was, I think the attempt of this was to encompass harassment as well as just sexual misconduct. So sexual boundaries covers both of those topics, and, that, I'm disagreeing with rewording that, but as far as just rolling it into 11 and saying 1 hour must include 1 hour of sexual.
I like having it separate if it's just a little broader to cover harassment issues. What is our course through the DCA labeled?
Sexual harassment prevention, but we don't regulate sexual harassment. We don't regulate, if you tell inappropriate jokes to your employees, we have no jurisdiction over that.
But we could argue that that is commonly what starts with a patient that leads to inappropriate behavior. So it's not
true.
It's having that boundary that's extremely important, and we're defining sexual boundaries. One person's going to label that as we both had our clothes on, whereas someone else is going to interpret as it being uncomfortable and harassing behavior, and I think that's the thing that we need to mitigate.
Yeah.
So the definition of including but not limited to misconduct or harassment between a licensee and their patients and or staff isn't.
Well, I like it with our staff, but we're talking more about patients, right? That's what our job is.
Encompassing.
Yeah.
Because our law does prohibit sexual with your staff. It's not just patients; it is with your staff. So I think it's important that we include that there. But yeah, it's there's a fine line sometimes between harassment and misconduct.
So I'm saying if it's a little more overarching, people are going to understand that.
Yeah.
They need to learn both.
They need to learn both what, sir, Dr. Eslino?
Harassment and
Yes.
sexual boundaries.
Which is-
And the crossing the line of sexual harassment or that boundary happens before they actually have sexual misconduct. And I'm trying to say if we educate them on that, we're probably going to save a lot of people from crossing that line.
So are you
which is
suggesting
why
that
the
we reword
definition-
this to say sexual harassment, including sexual boundaries? Would you suggest flipping those? Would that?
I would. Like I said, once again, I don't see why we should. The DCA has done a great job with that program. I don't see why we need to reinvent the wheel here. My vote was to see if we could actually get that program from the DCA.
Yeah.
And that part of continuing education for licensees, because I think it would be extremely helpful for them to be able to log in online and do that. And instead of forcing a continuing ed provider,
not
because
forcing a continuing education. I'm saying, are you saying that exclusively and not having people teach continuing education in this area? That they just
Yes.
take that?
that would be my vote, because that program has already been vetted. It's already being taught at the highest level, and you're not going to be able to get a continuing ed provider, or likely not be able to get a continuing ed provider to provide that course at that level. And it's action packed, and it has so many great points in just a 2 hour period.
Great points, but
I
it's
can-
not specific to patient relationships.
Yeah, I can address that briefly. The topic could be something like sexual harassment and misconduct prevention. But the sexual harassment prevention training that's offered through DCA is geared towards workplace sexual harassment prevention under the Fair Employment and Housing Act, which is a different set of obligations than what we're dealing with here, although they're related. On the conduct or the content of the training would likely be quite similar, but the audience is different, and I think that there are aspects of the training that would make it inappropriate to use the exact program that's being offered for state employees. That's geared towards a different environment. But I think that the overall topic of sexual harassment and misconduct prevention would be an appropriate classification for that would fall within the board's jurisdiction, and that could be a viable topic for continuing education.
Point taken. But since we have a representative here from the DCA, I'd like to go on the record and say it would be wonderful if the DCA could put something together, given the number of chiropractors, the number of physicians, the number of dentists, the number of nurses, and I think that would go across the board, and there's no reason why we should not be offering 2 hours of continuing education to all of our healthcare providers in the state to have some overarching, very comprehensive sexual harassment, sexual boundaries issue done on a professional level, because you can't log in and log out of that program without taking the test and whatnot. And I feel I'm more comfortable with there being a professionally produced program like that that covers all the topics, because you know it's vetted appropriately, legally and whatnot, than to empower some chiropractor. Although I think we need to do this, but until that program's done, I would defer to the DCA, and I'd love to see that mandated. So hopefully we could get some legislators to write that up and get that through, because in this day and age, I think it's very timely.
So as a provider, when I look at this question of sexual harassment, ethics, and boundaries, what I see is another application and another $50. So every time you tease categories apart, it creates more work for us, and I think more work for you. Another application to review, whereas when it used to be one category, we could submit one application. And so I just want to put that out there, that it makes things more complicated and more expensive to tease these categories apart and ask us to submit separate applications for each category.
Thank you. All right, any more comments about number 12? So number 13 is not ready for a whole lot of discussion. We have a separate regulation in the works, not in the works, on our list about CPR, basic life support. We are trying to address the possibility, instead of having that as a completely separate regulation, as rolling it into the CE regs, because I think it would be less confusing for licensees to not have this whole separate CPR regulation that they have to keep track of. We want to roll it into the CE regulations. So that's what we're going to try to do, and that's a work in progress. Any comments? Any public comment? Okay.
I can add a tiny little bit.
Sure.
My Nebraska license requires CPR every, I think it was 2 years.
Mm-hmm.
So maybe doing something along those lines where it's not a yearly, but
Nope.
every.
Our current regulation, the way it's written, well, I shouldn't say our current regulation. The regulation that we have in line to work on is an every 2 year. It wouldn't be an every year.
Well, actually, the regulation would mandate that
That you're
every
current.
licensee has to have a current certificate in
And that's every
CPR.
2 years, yeah.
But then we also, if we're going to require licensees to have a current certificate, we want to be able to give them CE credit
for it.
But then we're taking it to another section of law, and it's going to be confusing for licensees. So we're trying to think of how to have these two come together so that we can fairly compensate licensees for the time they spend doing that, but keep it simple. So-
Yeah, thanks. Okay, number 14, we actually added this after our committee meeting on Friday at the input of Lori. So basic sciences, she noted that the basic sciences weren't included in any of these other categories. So right now, the regulations define basic sciences. But that's our discussion for the board. What do we want to consider? Can I see your presentation? What do we want to consider as part of the basic sciences? Right now it is, what's in here? Basic sciences right now in the current regs are anatomy, histology, neurology, physiology, nutrition, pathology, biochemistry, or toxicology. So we're trying to define basic sciences. Sergio.
Sorry, Lori. Didn't mean to disagree with you again. But
She hasn't even said anything.
I know, but she's one of those. I personally would scratch this topic because I think, it should be clinically based. And I think we have enough in there that if you want to teach toxicology, if you want to teach anatomy, I mean, there's a difference between learning just the anatomy or cell physiology. I mean, who really wants to sit down and learn cell physiology, and how is that going to make them a better practitioner? It has to be clinically based, in my opinion.
One of the suggestions, and Lori, please correct me if I'm wrong, is Life West, you have that anatomy lab class. You go into their gross anatomy lab, and that's pure anatomy. So the question is, I think that's a valuable class. I think that would contribute to clinical competency. How do we see this fitting into the categories that we currently have?
I think that's extremely valuable, but I also think going into an anatomy lab and picking up a scalpel is different than going to an anatomy lab as a chiropractor and actually studying some of the spine or whatever it may be. And I think that I think if we could add clinically related anatomy or something of the sort to that, I don't see where we could add it in right now besides having a separate category.
You're
Right,
you're asking
that's
how
the
it relates
concern.
to what's going on before?
I'm asking, so one of the inputs that Lori had was they offer this class. I think we would all agree that's a clinically relevant class, but it doesn't fit into any of the 13 other category subject areas that we have here. How could we make that fit in? And that's where the discussion about basic sciences came in. So she was going to submit her course and the anatomy lab. What one of the 13 categories would she submit it in? And we really couldn't find a good answer to that, so that's where the discussion of basic sciences came in. Well, among other things. So
There is none.
that's,
But that course is being taught from a clinical perspective, isn't it, Lori? So I think I'm just suggesting we put a clinical spin on it. It's not, I think the course is already happening in that, we're being taught in that manner, and certainly all of us as practitioners can see the benefit, but taking a cell physiology class or a histology class.
I know, but I'm just saying that was the impotence of this
Okay.
basic science. So could we say basic sciences in regard to clinical practice? Do you want to just say, do you want to define basic sciences as anatomy, physiology, neurology, as related to clinical practice? I don't know how you're comfortable wording that.
Clinical pharmacology, toxicology.
Pharmacology, they can get from other boards. Yeah. So,
Why don't you do the anatomy and physiology as it's related to clinical practice and patient care?
do you want neurology in there too, or just anatomy and physiology?
I think neurology is covered in there as far as physiology, but
Okay. As related
all of them, but.
to clinical practice. All right, so now the suggestion is anatomy and physiology is related to clinical practice. Lori?
Biomechanics.
No, I like
What
it.
about biomechanics or physics?
Lori, I'm sorry, but.
But wouldn't that be
we need you to
included
go
in
up there
assessment,
because otherwise it's
biomechanics?
gonna be recorded.
I think
Adjust-
that's other.
I would
adjustments,
like to include
adjustments.
neurology in that list.
And it's Palmer Pete again. I see no reason, if it's important enough to learn it in chiropractic college, no reason to limit any of those. If somebody wants to study histology again, I don't see why that would be necessarily a bad thing. It's definitely something we learn in school. My wife's in third quarter now at Life West, and she's asking me questions all the time, and I'm amazed at how much stuff I've forgotten. So So, you're right, okay. I'm getting my hours right now. So I don't see any reason, I think it's a great idea to include it, and I see no reason why you can't include the whole laundry list that you read earlier. I would mandate that, but I'd give the chiropractors the opportunity. If they want to fresh it up on microbiology again, more power to them. That's my opinion.
Besides anatomy, physiology, and neurology. I mean,
Biochemistry will be in nutrition.
Yeah, that's, biochemistry falls in there, physiology.
Yeah.
Yeah, anatomy and physiology covers everything, even.
I think
I
it's
mean, you
pretty
could say
broad.
clinically related anatomy, physiology, and the medical sciences, and then,
That covers everything else.
Okay,
And medical sciences actually covers
all right, got it. Okay. Hi.
Hi, my name is Laurel Plubel. I'm a doctor of chiropractic for about 24 years in practice. I'm your fan. It's already written in our regs, so. Okay, well then why don't we just include all of these things so then if doctors did want to go back and do this again, it's all inclusive. Okay, great.
I'm sorry, which Dr. Pete was suggesting, hey, let them take it all. Right now, as it stands, we'll bring it back to committee and discuss it. Some of the language that we're considering is anatomy, physiology, neurology, and medical sciences related to clinical practice. The main thing we want to stress on is that it's related to your clinical practice, because we're trying to make sure clinical competency. So. But yes, the topic of discussion was what's considered basic sciences. We do have it in our current reg, and do we want to change that? So I'm going to bring the comments of the board and the comments of the public back to the committee, and we'll come back and we'll talk about it again, Dr. Plubel.
Just a side note, I want to encourage all of you to participate in our next committee, licensing CE committee hearing, because that's where a lot of these things get hammered out and then the recommendations get presented to the board. So as you can see, there's a lot to discuss. And so if you're not on our mailing
I was
list,
just going to say that. If you're not on the board's mailing list,
go to
you're on the mailing
our
list.
website and join our mailing list, put in your email address, and then you'll be notified of every meeting. We don't send a lot of emails, so don't worry about that. But every meeting, if there's a change in the law, anything significant, we send out notifications to our mailing
That would
list.
be great.
And tell your friends.
You can also see all of the board.
How come we're not,
You have to sign up, yeah, because we can't mandate that you
mandated.
give us your email address.
Also on chiro.ca.gov, if you click under board meetings, it'll tell you all the board meetings and all the notice committee meetings, and you can see when they're going to be and where you can participate in them.
We
So
have
if you don't get an email, go on the website chiro.ca.gov.
yeah, because this is just word of mouth that I found out about this meeting today, so.
Chiro.ca.gov will tell you everything you want to know.
We have a great website. In fact, we have a brand new board member, as I mentioned earlier, and my first conversation with her, she said she had been looking at our website and she gave us kudos. So please go to our website and tell all your friends and colleagues.
Okay, we want to move things along, and the last thing I promised we talk about was philosophy. It's not a category, mostly because it's wildly abused, and things are put under philosophy that are not clinically relevant and not part of CE. So my suggestion would be a definition of philosophy. Make it easy for us to include it, because we're chiropractors and we like philosophy, but we need a way to include it so it's not widely abused. So in the essence of time and where we are in our agenda, I would love for the public here to maybe give us some suggestions for how we can define philosophy to make it clinically relevant for the licensees. Not necessarily right on the spot. I would love you to bring that to the next committee meeting, or Robert, could they get the information to you? They could. How would they do that?
Robert.Puleo, P as in Peter.
Hold on.
I'm waiting for him to get his pen out. Robert.Puleo, Puleo, at dca.ca.gov.
Dr. McGillican.
This is why I came here
Quick, please.
Very quickly, my diplomate is in philosophy. I'm a Sacramento chiropractor. I came down here specifically to offer up any and all that you guys need as far as creating and defining clarifications so that we don't lose this category or this as a topic. And I'm happy to help out in any way. It's not a simple email. I think it's going to be a lot more work involved, but understanding the nuances and the ins and outs of our philosophy the way I do, I think I could be of value to this committee or to this board. So that's all I wanted to say was I find it extremely valuable. It's one of the 3 tiers, and I think we all know that. But if that's something that you guys are willing or would like to have, that's what my postgraduate studies are in. So, thank you.
Thank you.
So now I'm actually going to tell you who I am. So I'm a chiropractor. I also work at Life, but I sat where you guys sat for 2 terms on the Vermont Board of Chiropractic Examiners. And I would simply say that chiropractic philosophy tells us the why of what we do. And if a practitioner understands the why of what we do, he or she is a lot less likely to stray beyond their normal scope of practice. So I would say that it's actually in the public's best interest for a chiropractor to be able to stay strongly rooted in philosophy because it makes them a safer and more compliant practitioner.
Thank you.
Thank you.
And I just want to point out from the board's perspective, the fact that you don't get CE for a course doesn't mean you can't take a philosophy course. It doesn't mean you can't take lots of philosophy courses.
Sure.
I'm not disagreeing that it's important. I'm just pointing out so we remember the big picture that CE is not the end-all and be-all of classes that chiropractors can take. Just letting you know.
All right.
Okay.
Very well.
Hold on, I would like to add something. Also in that, in saying that though, chiropractic has our 3 pillars: science, art, and philosophy. And that is our foundation. That is first and foremost in how we serve our people when we are serving in excellence and in love of healing. So for you to choose to eliminate that opportunity to receive philosophy during the course of our CEs, I think is a huge disservice to our profession. My humble opinion.
Okay.
Thank you for hearing me.
So the next topic on this licensing and continuing education report is mandatory hours. Dr. McGilligan, your point is well noted, and it will be brought back to the committee. And I think many of us are in agreement on how to modify that a little bit. This is how it stands right now because we think that these are important categories for clinical competence. They are also things that we see often in our disciplinary actions. So I would like to have board members comment to bring back to our committee on mandatory hours. So 4 hours of assessment and diagnostic procedures, 4 hours of chiropractic adjustive technique, 2 hours of ethics and law, 2 hours of sexual boundaries, maybe 1 hour, and 2 hours of record keeping. Any comment from board members?
The 4 hours for continuing education assessment diagnostic procedures, you say qualifying subject areas number 1. I'd like to maybe say 1 through 4.
1, 2, 3. 4 might
Maybe not-
be a
maybe
little,
not 4.
maybe not 4.
Oh, where would you put 4? Because if it looks like you're trying to group the
No, we're not.
numbers, is it not? Okay.
We're not trying to group all 14 subject areas into mandatory hours. We're just saying of these 14 subject areas, we want mandatory hours in these. And I'll bring back to the committee 1 through 3.
I think grouping some of those, because 4 hours in this, 4 hours in that one, and pick and choose in which area the hours get used is important.
Okay. Any other board member comments? Any public comments besides Dr. McGilligan's?
So it's Paul repeat again. I just concur with Eric's comments. That seems excessive.
No. Thank you. All right. That concludes the continuing education and licensing committee report. So
forgot the other half of the report.
Yes.
what did I forget?
I'm kidding.
Oh,
How long is the report?
I know, but you know, I'm gonna tell you what we talked about in our committee is it's slow. We want to make sure. I think Robert pointed out it's important to get comment from board members and the public on this stuff. We'd rather do it right than fast, and we're really attempting to get it done right.
But we want to get it done while these members are still on the board.
Yes, we do. Number 15, update discussion and possible action on enforcement committee.
Okay, well, we're gonna go lightning speed here. We have been revamping all the experts. So those of the public understand that the expert witness or the expert consultants are people that are employed by the board on cases to review possible infractions, possible cases that are being investigated. And so we've done several things. We've gone through the entire expert witness and reviewed the entire expert witness program. We've reviewed quite a few things that are on the minutes. Let me get you the date on that here because I'm not going to go through them all. The minutes from our last meeting. I'm sorry. From May 31st, 2018. And some of the issues that were discussed were not limited to how we're choosing experts. We're looking at specifically the minimum monthly hours in practice. We're looking specifically at their experience requirements. We've determined that we'd like to have them have at least 10 years of experience in practice, what the disqualification criteria are. For instance, if they've had a complaint against the board, if they've had investigation or something of this sort, they are not going to be qualified as experts. We also want to make staff's job much easier and to have them be able to reference some true subject matter experts so that if they have a case involving a child, that they will have a list of pediatric diplomates. If they have a case involving a neuropathy, they have a list of neurology diplomates, and so on and so forth. So we are going to make some efforts at sending out a list or sending out a request to many members of our community that are specialists and diplomates, not to say that someone else cannot serve in that capacity if they're not a diplomate, but we at least want to have people that we know are vetted through a secondary credentialing agency. We also, one thing that we discussed last time, and I just want to verify that this is happening, Robert, is that when an individual has been notified that there is a complaint open against them, we are sending them a link with all the rules and regulations so that they can bring themselves up to speed on all that.
We're not, I'm sorry, I'll talk to our enforcement manager about that tomorrow. But what we've been doing is at closure, we provide, so we let the licensee know the outcome of the complaint, and we provide them with the link or the information for our regs and our act so that, and encourage them to,
And it is a desire of this, it is a desire of this committee that we do that proactively, so not at closure, and certainly we can't do it before the complaint has been notified that there is a complaint, but once that complaint has been opened up and they're aware of it, I believe, and I use the analogy of traffic school, if someone has a speeding ticket, they go to traffic school and they have to learn all the rules and regulations, and the hopes is that they're going to be a better practitioner, just as if they have a violation for advertising, it behooves us, and it truly is in the spirit of protecting the public, that they review all of our rules and regulation and see where they could be a better practitioner. So a simple link, I think, is easy to do via email.
Definitely, yeah, and we can incorporate, because we send out an acknowledgement letter, or so when we do that, we can add a blurb about, if you can refer to the board's act and regulations at this link.
Sure. So another thing we discussed was that there must be a minimum monthly hours in practice for subject matter experts. We define that at 80 hours a month in direct patient care, clinical activity, or teaching, and at least 40 hours are in direct patient care. So they can be an instructor at a school, but they must have some actual direct patient care. We have not determined what the specific number of hours for continuing ed hours we will provide to people, but certainly they should be, in our opinion, as the committee's opinion, be provided continuing ed hours if they're serving on the committee or if they're serving as subject matter experts. We also discussed having them render some sample reports and a statement of qualification on why they want to be a subject matter expert and have them provide us a sample report. We've discussed doing a screening. Staff will do the initial screening of the applicants, and then the enforcement committee or board members, we will determine how that will play out in real life. We'll actually have a brief interview with these subject matter experts. And that pretty much sums it up. Any questions among the board members?
I have one question.
Yes.
First, I read this and was blown away. I think this is great. I love everything that you've done with this. One thing that we did, I think we've talked about in the past, and that instead of having a writing sample, that they get a previous disciplinary case and then have to write up as one of the experts would write up that disciplinary case. So they get an old case that's already, that the board has already had, and then that would be a great way to vet what's going on, especially if it's a case that we have had
Yeah, the only
issues with in the
challenge,
past to see how they handle it.
only challenge with that is the amount of time that it will take for them to do so. And so if we could find some cases that would only take them an hour or so, but the point with the expert report or a sample report is most of these individuals, if they are adept at doing this stuff, should have a report lying around their office that they've just
Well,
recently created.
Why don't we give them a choice?
So that's not clarified in the memo, but the plan is to have them provide, so we will, through the work of the committee, will staff will pull a bunch of cases, we'll find a case that will be an example of something where we can establish a baseline metric to grade these folks. So we'll provide all of the applicants a case to review, they'll provide it back to us, so we can, and then the committee, the actual licensee members will render a rating and judge all that stuff. So Dr. Dane, for you, that's what's going to happen.
In the writing sample or separate from?
Both, not either or, it's both. So the writing sample is determined. So that's kind of like the initial gateway. So we want them to explain why they want to serve as an expert.
Those are two different things.
Yes.
Statement of qualifications and why they want to
Definitely.
serve, and then the writing
We
sample.
want them to explain to us why they want to serve,
Mhm.
and so that will serve as the writing sample. But we also want to assess the technical ability as well to render judgment. So,
Yeah.
So
I think
it
that's
started
important.
out as a question of either or, but the committee determined that both were important to make an assessment as to who can serve as an expert.
So they're gonna have a writing sample of this is why I want to be an expert, and they're gonna get a previous disciplinary case to evaluate.
Yeah.
Great,
Create a report.
good.
Correct.
And what I failed to mention is that
Great.
staff did a great job in going through, and we went through the entire
Great.
application and weeded out a lot of, there's a great deal of redundancy in there, and we modified quite a few things. One thing that most things said knowledge and experience, and we've modified a lot of that
It will
because,
be. I haven't done it yet
Yeah.
till last Thursday, but
yes,
it
I
will
noticed that. Thank you. Any other questions? Okay, let's move on.
Excellent work. All right, next agenda item. Update, discussion, and possible action on governmental and public relations committee meeting agenda. So there's several things to talk about with the Government and Public Relations Committee. We're going to start with the first thing, it was in your supplemental folder. We updated the dates on the strategic plan. But let's move on to the board members' administrative procedure manual. And I'm gonna point out the changes that were discussed. by the committee. On the committee is myself and Dr. Lickman. So the first change is on page 11, the Bagley Keene Open Meeting Act. Sorry, I missed my first marker. The first change is page 8, which is the role of board officers. So the role of the board chair, vice chair, secretary are outlined. This was in the meeting packet that was previously given to people. All of the changes have been underlined, so it should have been easy for you to identify. So any comments about role of board officer definitions?
Anybody? I guess I'll start.
Yeah, please.
I think, first of all, I mean, this is just a suggestion, but I don't necessarily need to do. I think we may want to, in the interest of time, refer back or reschedule it, because there's a lot of stuff in the manual, I think, that are in conflict that needs to be looked at it. So I'm not sure if we wanted to tackle it.
Well, if you know what those things are, it'd be helpful to identify, because if it gets referred back to committee, it's helpful if we know what the concerns were.
Okay.
Or the conflicts.
All right, then, so starting at page 8, some of the duties that they're outlined on the board chair, it is my opinion that we need to take a look at it in terms of, for example, establish committee and appoints chairs and member. I think that's very appropriate for the chair to do, but with the board concurrence. To give one singular person, the board chairs, to the best of my knowledge, is not the chief executive officer of the board. It's just a peer, and we shouldn't, that individual or that position should not have absolute authority. Just like, the president of the United States appoints, but the Senate gets to approve or disapprove. They don't get to decide who, but they have a say in that process. Likewise, the governor, he gets to appoint. And the Senate gets to not all the appointments, but the vast majority gets the full board gets to, or the Senate, gets to decide or gets to weigh in on the appointments. So I would suggest, for example, that the chair establish the committee, appoints with the board concurrence, or the majority concurrence. The other thing, if you look on the second, the board vice chair, this is just a very minor thing, is a backup for the duties above in the president's absence. So I think we should either call it chair or we should call it president.
That was it.
I would say just, yeah, okay, no problem. Just, I mean, that's just no big deal.
We actually researched multiple boards, if they had definitions. It's just, we wanted to be consistent. So that was just an oversight.
Yeah, the approval of the board meeting agendas, I believe it's been addressed in another section. It's along with the secretary, so that might need to, we should look at that. I believe it, and the executive officer could correct me if I'm wrong, but I believe also verify accuracy and approves travel claims. I believe the chair, and I could be mistaken, currently the practice is that the chair also approves the board members. Is that correct? The chair travel expense claims? Does the chair approves the travel expense claims, right?
Yeah, the board member,
the board, yeah.
It says I'm sorry, under the board chair, it says verifies accuracy and approves timesheets, approves travel.
And signs
travel expense claims.
for the EO.
Oh,
and the board members. Because I believe that's the practice right now, right?
yes.
Initially, until I heard the presentation today by counsel, I had it added executive committee, which it's not included here. But after hearing the discussion today on the, on the Open Meeting Act, that obviously they cannot be a discussion. So I believe it's on section 11. Well, when we get there, because it talks right now communication among the officers, there's a section that includes the chair, the vice chair, and the secretary. So we should clean that up because it appears, at least from my perspective, that may be in conflict with the Open Keen Act.
Yeah, where is that?
Yeah, so, excuse me. Let me go to that real quick. So if you go to page 18, and I wait until you guys get there, page 18, it says communication between officers, and right now it says the chair, vice chair, and secretary must have, so it's not even should have or may have, it's not even permissive, it's must have timely and effective communication for the efficient operation of the BCE. Well, given what we heard this morning, or earlier today, this might be, I'm not really sure, this needs to be the cleanup, or we should totally eliminate it because that could potentially violate the.
I don't think this is suggesting that all three are communicating. It's just that if a board officer is reaching out to board members, they need a timely response. And actually, you could argue that goes true for any board member. If you're trying to communicate with other board members about board business, like scheduling a meeting or something like that, it's helpful if I don't think that's been a problem.
It confuses me though.
Well, I actually was looking at it the other way, and I think we should practice that more.
Practice what?
More timely and effective communication among the executive officers. I think there's quite a bit that we could discuss that's not substantive to being in violation of the Bagley-Keene Act.
I think there's quite a bit that we could discuss that would not be subject to the violation of the Bagley-Keene Act. If we're dealing with administrative things and whatnot, that's not going to compromise us, is it?
The officers can discuss the agendas, planning, coordination of meetings, those sorts of things, but not the policy decisions that would take place at the meetings.
Currently, we only have two officers, that it's the chair and the secretary that approve the agenda. It seems that there would be potential concern if you had three members deciding, because then what does or doesn't go on agenda could influence policy. So it seems like there should only be two members involved in approving the agenda.
And I think, if I may, because this, when I first got appointed to the board, there was I recalled, there was a huge concerns about the agenda and about how the chair prevented agenda items to be placed in the agenda. And that's why I said, it's sort of we need to kind of take a look at this about whether it's two, whether it's three, but going back to page 8, right now says approves, it appears right now that the chair has the complete authority to approve the board meeting agendas, and I'm not sure if that's the intent.
No, we'll clarify that because it's the chair and the secretary. It says that under both chair and secretary that they approve agendas because that's one of their responsibilities, but they do it, the chair and the secretary combined. So when we draft the agenda, we send it out to the chair and the secretary for approval. We get their feedback, and once we have agreement of those two and legal counsel, then the agenda is approved.
Yeah,
so,
no, and
so
I
we
get
can
that.
clarify that it's the chair,
But right now, as it is
along
written,
with the co-chair.
yeah, that's what I'm saying.
Yeah, but the process is chair and co-chair, and we'll just clarify that in here. Oh, chair and secretary. I'm
Yeah.
sorry.
If you go to page 10, agenda items, so again, we're dealing with agenda items. So board members may submit agenda items for a future board meeting during the future agenda item section of the board meeting or directly to executive officer 21 days. I'd like to insert secretary as well, because secretary is my understanding, it's one of their role to prepare the agenda. And then the last paragraph.
I'm sorry, Mr. Rufino, but it doesn't, it's not board members may submit agenda items for a future board meeting during the future agenda items, or directly to the EO. It's not the EO and chair. So it's,
No, I like to add secretary to that, to the EO and/or secretary. The secretary should be included.
Added to all three, added to the EO, the chair, and the secretary.
No. Just the secretary, because as I understand, the secretary principal role is to prepare the agenda, right? Am I wrong?
No.
Approve it.
just, yeah, along
Not to
with the
approve
chair
it, but to facilitate it.
It's just to approve it.
Well, of course,
So if a board, because the problem is, it, potentially, if you discussed with Dr. Lichtman, oh, we should put this on the next agenda, and he agrees, so then you send me and the secretary, Dr. Azzolino, an email, then you have a serial meeting there. So it's, you know, and there's no chance of me withholding something, because if I do, then that's an issue. But it can be addressed at the next board meeting. It's like, I requested this and it wasn't put on the agenda, and so you bring it up during future agenda items. But I don't,
right.
it's not the secretary's
all right, I mean, I can
primary
live with
function
that.
to do agendas. It's,
I'm just looking at the big picture. I'm not looking specific individuals. But on the third paragraph, it says, in the event of a conflict in scheduling an agenda topic, the board secretary will discuss the proposed agenda item with the board chair, and the board chair should make the final decision to schedule the item at the upcoming following board meeting. So, is that what the board wants?
Well, it was actually an issue now that you mentioned it some years back, like 7, 8 years.
Of course it was. I remember.
we have, it's addressed elsewhere in the, oh, it's addressed, it's addressed elsewhere, for, I'll have to find it. But if, because if a board member wants something on the agenda and the chair doesn't, they can, because it has to be put on the agenda. It may not be for a specific meeting, because the chair may determine we already have too much on this agenda. I know that Mr. Ruffino wants to discuss X, Y, Z, but we have too much, so it has to be, but I apologize, I wasn't prepared to, so I don't know exactly where it is, but there is a provision in here that says that it shall be placed on an agenda.
Is it possible, just in essence of time here, and that Mr. Ruffino submit some of his concerns to you, and then we all can take a look at this and,
Well, to be honest with you, what I was gonna suggest later during the future agenda items, to actually have the full board take a look this whole manual. And so that we can all bring, rather than one person, we can all look at and bring our concerns and our questions. That way we can all address them at the same time. That would be my suggestion, but I may be out of order
Yeah,
right
well,
now.
I mean, the fact is, and we can do that, but the changes to the administrative procedure manual was on the agenda for this meeting, so all board members had an opportunity to recommend changes that weren't in here, you know, that weren't proposed by the Government Affairs Committee. So, but certainly,
Let me continue then real quick.
we can, if that wasn't clear, we can do it at a future meeting.
So on page 18, again, the communication between officer, we already addressed that, but on the committee appointments, again, the composition of the committee and the appointments of the members shall be determined by the board chair with board approval. I'd like to add, with the board majority, not full approval, but with the board approval.
so we take a note.
So these are some of my concerns anyway.
Okay, so the board, and I'll turn it over to Heather, but the board can vote on any of these if the board wants to accept Mr. Ruffino's recommendations, or at least put them up for vote. You can do that if you want to do them individually, or if you don't, if everybody wants to just accept them and say we'll we'll adopt this as, with the suggested changes. So that's something that the board can do right now.
Well, there's one thing that we didn't quite get, one of the issues that Mr. Ruffino had that we didn't quite get resolved was the one on page 18, about the communication. I'm unclear if you wanted something added to that. Do you want something added to there that says, this is not to be interpreted, communication must not be in violation of the Bagley-Keene Open Meeting Act? Would you like a sentence added on to that, or do you want it to stay as it is? Because I think the intent of this paragraph is, like Mr. Pulio said, is to respond to emails that, the executive officer sends or something like that. So, but if it's confusing to you, would you like a sentence added on there that says this is not intended
Yeah.
to contradict the Bagley-Keene Open Meeting Act?
Yeah, I think that would be helpful, but just so, you understand where I'm coming from, my interpretation of this is that, I looked at this, the chair, the vice chairs, and the secretary, and we mentioned it before loosely as the executive committee, that would meet and would, so in that, and what I'm hearing now is that it has a whole different.
Right.
So I am obviously in the wrong,
To avoid
avoid that.
confusion in the future.
correct,
it
either
would
for
be
me or
good
for a new board member.
to add a sentence onto that.
Yes, I
Okay.
think we should clarify.
So,
And also to clarify too that it will not be in conflict, with the act, yes.
oh, that's what I'm saying.
Yeah.
That to add a sentence onto there.
Yeah.
So what I'm hearing, in case we want to vote on this, is that you would like, under the responsibilities of the vice chair, change president to board chair. Under the board chair's role, approves board meeting agenda with the secretary, establishes committees and appoints chairs and members with board concurrence.
Yes.
And then the other change was adding the sentence on to communications between officers about the Bagley-Keene Act.
Yes.
And then under that, the chair shall establish committees, whether standing or special, as he or she deems necessary with board, the same language as before.
Yeah, basically the
with
second-
board concurrence.
The second sentence, yes, with board concurrence.
I have something that
That's
just
it.
came up here now. Should we just make a motion?
Well, there's more changes that I'm gonna go through. I just wanted to make sure we
Okay,
had
but should-
Frank's on record.
That's what I'm saying. Should we deal with all the changes, or should we just make a motion to either approve or deny his changes and then move on to the next issues? What would be better?
There's no motion pending, so if this exercise isn't gonna take too long, it'd be more efficient just to go ahead and note all the proposed changes and then
Okay.
make a motion to adopt those.
So page 8 was the first thing I wanted to point out with the board, the role of board officers. The next one,
I have something there. Should we comment on that while we're there?
yes, you should,
Okay.
absolutely.
Did somebody have something?
She wanted us to,
Okay, so just in looking at this here and thinking about our succession plan on how what we've talked about is training additional people to come through the executive officer positions, or not the officer positions, I'm sorry, the executive committee positions.
I'm sorry, I just want to be clear, there's no executive committee, there's board officers.
Board officers. And in spirit of that, it seems like if we look at this list here, things are heavily weighted on the board chair. The vice chair has nothing to do, except for wait for the board chair not to show up. And the secretary has minimal things. So if we look at the first issue under board chair, act as spokesperson for the board, attend legislative hearings, testifies on behalf of the board, attends meeting with stakeholders, legislation, and legislators on behalf of the board, and talks to the media on behalf of the board, and signs the letters on behalf of the board. I can understand things that are very clearly need to be assigned to the board chair, such as signing the letters. I would like to see that all of those other issues there, that we have the most qualified person. Otherwise, it's really going to be incumbent on us to make sure whoever we vote in as chair is an expert in all these things, where we may have somebody in among the ranks that is better at spokesperson. There may be somebody that has some expertise in dealing with legislators. We obviously have that with Frank, and we have that, we had that with Julian. So I would like to see that some of those roles either be broken up, or the board is just coordinating whoever may be best for those things, because truly I think in order to have a successful board, we need to have the most qualified person providing that service, and whoever may be next to be by their side for those meetings, or at least be mentored for that issue. Otherwise, one person's going to come in and another one's going to come out, and we're starting over from scratch. And I would hope that each successive board member is going to be better and better trained. And certainly, we all learned a lot from Julie. I think there's things that we can still continue to learn from Frank, and on from there, I'm sure our new board member that's just come aboard is going to have a wealth of information to teach us. And so I would like to see this broken up or reworded in a sense where the board chair may be coordinating these things, but I would like there to be an understanding that we're always looking for the best qualified person. And that person may not be doing this role just because they're the chair, or because they're the vice chair, or the secretary, or whatever it may be. I think if we look on performing what will be in the best interest of the board, the best interest of the public and the administration, then we're going to go with the best qualified person for that.
How would you propose that get worded?
I think we could put the signs letters on behalf of the board. That's already written. We could put signs letters and put it all the way down here, sign specific full board enforcement approval orders. I mean, the board chair is signing all the documents on behalf of the board, whether it be, and this is not something that I prepared before because I didn't realize we were going to be spending so much time on this. But in regards to proposing the other things, that the board chair will coordinate these activities among board members. I think it's incumbent upon us to use, the talents of each respective member and learn from them so that we could all get better at whatever skills they have. So it's going to require some wordsmithing there. I don't think we're going to, unless you want to do it right now.
Given
time.
Well, given time and given because we've discussed a lot, and Mr. Rufino expressed concerns or questions about some things, and some of those were answered. So on some issues, I'm not clear whether we need to change it or not. So we probably do need to
Take it back to committee.
take it back to committee. I would recommend that that each board member individually submit to me, look through this document and submit to me, not CC any other board members, any recommended changes, and then I won't identify the board members. I'll put those all in one document and just give it to the committee to consider those changes.
I think that's a good idea.
Forgive me, but in this particular instance, I'm going to disagree. I think I do not want, my preference is not to refer back to committee. My preference is to agendize for the full board. I'm not comfortable just delegating this discussion to two members of the board. I think it rises to a level where the full board needs to be engaged, needs to understand where we all coming from, make sure that we all kind of go through, just like what we did, the 14 points are very, very much like that, even though it's not my area of expertise. But it kind of we need to sort of go through this, taking our time without feel pressure, and make sure that we come up with some of the, that we all put our thinking cap ahead of time and come up with some of the best way to agree on how we proceed in certain areas, and and how we're going to share the responsibilities.
Well, that's exactly what happened with those 14 points. We took ideas, we talked about them, we presented them to the full board. So what Robert is suggesting is take your time, review everything, bring your ideas, and it's going to be presented to the full board again, just with the areas that board members want to see changed. If you would like, we can incorporate all the suggested changes, and then we can decide as a full board what the changes we want to be made.
It would be good
But
if we could do a red line.
I think it's hard to talk about this at a board meeting. I think it's much more thought-provoking, it's much more relaxed, it's much more complete if you can go through this at your leisure, make your recommendations, send them to Robert, and if you're not comfortable with the committee doing the work, then all of the people's suggestions can be listed and we can go through them as a full board. But it's not like you're not going to see this document again and have chances to comment on it. You know what your comments will be. Dr. Azzolino knows what his comments will be, or mine. I mean, that's what committees do, and you're not going to be cheated out of seeing this document again with your recommended changes on it.
Can you do a red line version on that, Robert? Is that, I mean,
Do a what?
just a red line version to track changes, and you could very easily just list everybody's individual comments on that.
Yeah, do we want to identify who suggested the comment or the change, or do we want to just put them in there? Because
I think
certainly we can
it's-
track changes.
I think it's healthy to identify, I mean, this conversation today was very thought-provoking and stimulating, and it's just, we came up with ideas on the spot.
Okay, well, I'll send the document to all the board members and ask them to individually submit their changes to me by a certain date, and then whatever we receive will be incorporated into a document that do we want to refer that to committee, and then that same document would come back to the board
Well,
ultimately?
if we're gonna see everybody's changes, I don't think.
So we don't need to, it doesn't need to go through, okay, just want to make sure I'm
Because
clear on what.
Committee would otherwise be doing some of the legwork so that we don't have to do so much, but if we were gonna have everybody's changes, and certainly I would like to have our new board member weigh in on this, because she may have some insight. It may be best just to bring it back to the full board with everybody's comments on there.
That'll be great. Okay, so I will.
We have to slate at least an hour or two on this.
Yeah, it'll take some time. So I'll send the document to all of the board members and request any comments or changes about any of the provisions and any suggested new provisions, and then we'll compile that information.
And we'll only do this in Northern California, so I don't have to miss a flight, because it's gonna be lengthy.
It's the next meeting is where?
San Diego.
San Diego.
Yes.
So two people will get home.
We'll start
finally.
at 8 in the morning on this.
So, do I go over the other changes in here, or are you guys just gonna
I
read it
will.
on your own?
Yeah, I think it's new.
I just want to point
I'm
out
sorry,
that we added a
Dr. Dan.
period.
Oh, go ahead, finish that and then
I
I'll.
just want to point out on page 24, that was some added language onto strategic planning to make it in the year of joint sunset review, and the periodic fee audit language that was recommended at a full board meeting got added in. So just make sure you notice that that's new language. Yeah.
Okay, Mr. Swenson just suggested that somebody motion to table this and take it, carry it forward to the next meeting, and,
I so move.
okay.
Thank you.
I'll second that motion.
Okay,
Any discussion? Any public comment? Call for the vote.
Dane,
Yes.
Lickman,
Yes.
Azzolino, yes. Rufino.
Yes.
hey, it's all up to you guys.
The next item is procedures for electing board officers. There's two sections to this. There are recommendations. There's 4 sections with recommendations. And then on the back of that page, there's staff recommendations for nominating and voting procedures. So, comment?
I just want to say that these will, we had this as a separate item on the
Oh,
government
you want me to-
affairs, but these would, no, I just want to say that these would be incorporated ultimately into the administrative procedure
Right.
manual. So just so everybody knows that this isn't just some passing document, would ultimately be incorporated in there.
We have the bill analysis, which should go fast. And that's it.
So I'm sorry, can we take a brief break?
Sure. 10
Um,
minutes.
sorry, I was just figuring out the flight scenario. Am I, am I,
No, I think we're
We're
gonna
gonna
just
take a break.
oh, we're
Yeah,
gonna take it,
we're gonna
oh,
take a
okay,
10-minute
never mind.
or whatever time.
Record for the meeting, and we are continuing on. Sorry, I lost my agenda item. Agenda item number 16. And again, there's a one-page document in here. The front is some choices about election procedures. The back is some staff recommendations. So we can open it up for discussion.
I guess I start. So first of all, I have a question regarding the 10 programs that were reviewed. Were there other boards or was there, what program? I'm just curious to know.
There were other boards. We looked at other DCA boards and what their election procedures were. I also did some general research about parliamentary procedure and election of officers and Robert's Rules of Order to reference their recommendations. And there's no one specific recommendation. It all depends on the culture of the organization. If you mandate or require one thing, then sometimes it limits your flexibility in another area. So there's no perfect process for electing officers, but based on everything that I saw personally, there were some that made sense in particular for this program.
Thank you for that. Also, may I ask of council, or actually, since we are so blessed to still have the DCA representative here. I mean, this is a first. I never remember having a DCA high-level official be here all day. Sorry for the long day of meeting, but you sign up for. It's getting, yeah, it's after 4:30. Seriously speaking, is there any guidelines or general guideline direction from DCA to all boards, or do you leave it up to the individual board based on their culture, based on their past practice, based on X, Y, Z, for them to adopt their own election procedure?
Good evening, Patrick Lay with the department. Well, first of all, always a pleasure to be here. Love joining the party, so thanks for having me. But yeah, in terms of elections, we defer to the board. You have the authority to decide how you want to run your election process and the procedures surrounding that. And all the items in the administrative manual is very much under your jurisdiction and purview.
I'd like to add to that. In the research we did do, we found that largely most boards or all boards do everything very similar. In doing this research, I did, some boards did some things that I thought, oh, that's a good idea. So it was a valuable exercise. But I didn't find a lot of deviation. And most boards conduct their elections the way we always have, with the nominations made at the meeting and the vote immediately following the nomination. I'm not saying that means that that's what this board should do, but that is the norm.
I'd like to say thank you to both of you for the input. I also want to say, and I want to make it clear as we discuss this, that nobody questions the day of the election process or procedure. That was done lawfully, that was done perfectly in accordance to the way we've been doing it. So just, I want to make sure that we all clear on that. No one has ever implied there was something wrong on that day. It was prior to, that's the key, that we all do not want to address, that we all don't want to talk about. It is prior to what transpired, what conversations, what recommendations, and who was involved. That is what I'm after. But that said, please don't misunderstand. Whatever happened yesterday, it happened yesterday. We need to look forward. And in order for us to and make sure, that we continue, that we clean. That's this. So I'm not here to talk about yesterday. Whatever happened yesterday, it happened yesterday. But I'm here to just simply suggest a fair, level playing field for everybody that wants or aspire to be an officer or want to be an officer. That's what I'm coming from. I'm not going back and what happened yesterday. Whatever happened, it happened. But from this point forward, I want to make sure that we're all on the same page. So that way I can play by the rules. Because if I know that I can do X, Y, Z, then it is my prerogative to do X, Y, Z just like anyone else can do X, Y, Z. So, all right, that said, another question and comment, probably not, but in all these research that you did, Mr. Executive Officer, was there anywhere, was it the concept of staff involvement in the election process? Was that addressed at all in these, or was that ever a concern of any other boards?
Well, it wasn't addressed. There's not comments on why they do things a certain way. But in some instances, the executive officer does send out a memo to the board members in advance of the meeting, and in some instances, they ask for nominations to be made in advance of the meeting, and then they will announce those nominations on the agenda. That I've just while I'm mentioning that, I've seen board meetings where that was the nominations were requested, but board members didn't submit nominations, and then they made them at the meeting. And so nothing's foolproof. It depends on the group of people and whether they follow those rules that are in place, and whether the rules are hard fast. If you say if you don't submit a nomination, by this date, then you've lost that opportunity. Some boards may want that rigidity. Some boards may have a problem with that. So that's the thing. You create consequences when you make a rule, and if it's a hard rule, then sometimes it limits you in other areas. So just want the board to take those things into consideration when looking at this, because I was trying to look at this very objectively and what makes sense just based on not just this board but other organizations I've been involved with, and what would assure that there's fairness and that the members are comfortable that the process was fair and they had an opportunity to participate equally.
Okay. I appreciate that. Thank you for that. The other comment that I have is that I'd like us to have a general sentence about staff involvement, whether staff should be allowed to play a role or not, and the consequences of either way, And the second thing I'd like for us to address, since we experienced this, to address the campaigning or the soliciting support of board members' votes by phone. I think we need to address that so that way everybody's clear what's permissible and that process. So those are two things that I think we should include in our in our protocol, in our nominating protocol,
Okay.
in our election procedure.
Yeah. So
sorry.
do you have recommendations in regard to both of those? That's what is it that you would like it to say in regard to staff participation and phone calls? Because the phone call issue is largely addressed by Bagley Keene, and that applies to election of officers as well. So that's, those rules would apply. But anything that you, in addition or instead of anything that's recommended here, now's the time to put it forward.
Well, I don't have verbiage, but I would like to suggest to the board, it's a board decision, it's that probably be better that staff would stay out of it, of the election process. They would stay completely neutral, and they would not advocate or would try to identify who's doing what. That's a political decision that needs to be addressed and needs to be discussed by the board, and the board has to sort that out.
Yeah, I completely agree, and staff never has participated in the process. What came up at last meeting, there was it was suggested that that the board members submit their nominations in advance. I think one of the suggestions that came up was to submit nominations to the executive officer. If that's what the board decides, I'm happy to do what the board wants. But otherwise, staff historically has never had any involvement in the election.
And just for the record, I want to make it clear, I'm not accusing staff.
No, I'm not saying that.
I'm just saying right now, from my experience, I came to a board meeting 2 years ago, I think it was, or a year ago, and I didn't even ask to be an officer. I was just, as I walk in, I was told, this is where you're going to be. Okay, no problem. If I can be of help, I'm totally okay with that. Then I came in at another board meeting and I was, voted out. So I'm trying to reconcile the two process, and I'm trying to understand what happened a year ago when that happened, what was the setting, what was the circumstances, and what happened this time. Not because I needed, an officer. I'm trying to reconcile.
I understand, but you're talking about two different things here. Appointment to committees is something that the chair does in consultation with the executive officer. Electing of board officers is a completely separate process. So there's two different things there.
Oh, no, I'm fully aware. I'm fully aware. I'm not referring.
You were saying that you were told that you're going to do this, you're going to be on this committee.
Yeah, I was told that you're going to become the vice chair. And
by who?
That's the past. I'm just, right now, I'm just saying right now, that's what I experienced, and I'm just trying to reconcile, and I'm just trying to make sure, that we are doing this. We have a way to do it.
And I'm not trying to be argumentative. I just want to make sure I'm clear, because I've been, I've been trying to make recommendations, and so if you have a concern that you want to make sure is addressed, I want to make sure exactly what that concern is, so we can address it, because it has to be addressed here.
Sure. My concern is simply that staff should not encourage, discourage, or being involved in the selection of the leadership of the board. That's all I'm saying. If we can live with that, I'm good.
I agree with that.
I'm at all levels.
I would add not only selection, but recommendation.
And recommendation. I think I said
because I
that.
think it starts with recommendation.
Yeah.
But not to cut you off here, Frank, I think we need to revamp and solidify some objective procedure that's going to mitigate any issues that we had last time around. We're not going to have another vote for 6 months. So is that something that we need to accomplish at this meeting here?
Well,
I'm not trying to shelve everything.
I think what we do need to accomplish, it sounds like Mr. Ruffino has some language he wants added to the board member procedure manual around the elections. We've already decided we're going to talk about the board member procedure manual or the administrative manual at our next board meeting. It's going to be on the agenda. So much like we're suggesting that you submit language for changes you'd like to see in the administrative procedure manual, submit language that you'd like to see as far as staff involvement in elections and Begley-King compliance in elections. So let's bring it back to the topic at hand and the recommendations that are made as far as changes to the elections.
Okay, so I'm clear. The first page is our recommendations at the committee.
No, the first page are options. They're not all the options.
Okay,
They're
but who came
simply
up with these options?
Staff.
Staff did, and,
Okay.
go ahead.
And
Alright.
the pros and cons of those options are given. On the second page are staff recommendations.
Okay.
More than more than able to make other recommendations, but I think that's the document we need to move on to, so that, again, we can have language, and when we go over the board member administrative manual at the next meeting, we can talk about it. If we're not gonna make a decision about it today.
And just to clarify, these options weren't intended to be limiting in any way. It just, there's only so many options you can have when you're nominating and electing. And so these were the possible combinations of how you could handle nomination and election. And these were based on concerns that were expressed at the last meeting.
Yeah, I'm assuming people had an opportunity to look at this, so if they have comments about it, now's the time.
Well, I do think that the one thing that we've discussed several times now is I think a statement, and a statement by the individual nominating themselves or accepting a nomination.
We did talk about that. I don't know why it's
Yeah, and it's not in here.
Just to be
Yeah.
clear, that was part of the committee or the staff recommendation in discussion with the committee. It was just my failure to put it in there. So that is something that was discussed and should be included on that recommendation.
Thank you, Marcus.
And there's a question of when and how should, and it also hinges on, like if we do the nominations at the meeting before, or if we do them, by an email to, if not the executive officer, perhaps to the board's legal counsel, saying, I would like to be chair because blah, 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 and then that would be disseminated in writing. Do we do it verbally at the meeting before or at the meeting the day of the election, depending on when you want to do the nominations? So there's a lot of possible combinations
Yeah, I
here.
think we need to limit, if people are gonna have a personal statement, if they're gonna submit it in writing, certainly limit the number of words.
We had suggested limiting it to 5 minutes.
Yeah, if it's
That would be a
verbal.
verbal statement.
One page if it's in writing or something like that.
But 5 minutes can get a little uncomfortable.
Well, that would include questions, and you don't have to make a statement if you don't want to, and it doesn't have to be 5 minutes. Oh, you don't have to make a statement, and it doesn't have to be 5 minutes, but, so,
And you put some thought into this, and Mr. Swenson, you may have an opinion. Is it best to submit these nominations ahead of time, submit statements ahead of time, so people can think about this rather than having to make a decision on the spot? I still tend to, and thank you for still being here, Patrick. I still think that one of the reasons why we're in the DCA is because to streamline things, and I would think that we should be able to streamline a process that all boards can benefit from, and mitigate this happening.
Yeah, and in response to, and Ken may have a legal perspective, but if it's a matter of the board's preference, the cons of doing it in advance, like say at the meeting before, is then you're limited. If you don't nominate yourself or nominate somebody else, and if you had to do it at the meeting before, and then on the day of the meeting you decide, oh, I changed my mind, I do want to nominate myself or do want to nominate somebody else. Also, it limits the flexibility in. So say if you want to be chair, but if you didn't get elected chair, then you would throw your hat in the arena for vice chair. So then at the meeting before, everybody who's interested in serving as an officer would have to nominate themselves for every potential position. It just gets a little unwieldy. So that's why,
I understand that.
Yeah.
But it also, on the flip side, eliminates, some people may desire to run for a position if someone else is not filling the seat. Or, it's limiting to have to wait to do it on the spot, whereas if you know ahead of time, people may be comfortable. If we have an incumbent that's there that they're comfortable with, then no one else nominates themselves. So.
True, and I'm not saying one's right or wrong. I'm just saying the pros and cons. So you, just so I'm clear though, so if the meeting before, if you're proposing that, it,
I don't have an opinion one way or another. I haven't put that much thought into which one would be better, and I'm assuming you guys may have, and so.
I put a lot of thought into this, to be honest, and looking at this objectively, and because my concerns that were raised were about it really depends on what's important to you, if as a board, because whatever you put into effect will limit alternatives. And so, do you want this instead of this, and that's, and I tried to, it was a little cumbersome, but I tried to spell out the potential cons of any
Sure.
given one, so that you could, if you do this is the good point side, but the bad point is that it would limit you on this front. So it depends on what's important to the board and how much flexibility they want. And there's also a question of should the board accept nominations by other board members, nominations or self-nominations by the individual board member, or both, because those kind of having that many options leads sometimes to confusion and misunderstandings, where if you narrow it, there may be fewer misunderstandings, because it's like, I can't nominate myself, somebody else has to nominate me.
Yes.
Or if I'm interested, I have to express that interest. I can't wait for somebody else to nominate me.
So the only way I could see that we could get through this meaningfully is we go item by item and we all vote on it,
I'm fine with that.
because I certainly, think one of the most important
Yeah,
things is.
I think that's a good idea. In some cases, the beginning dictates what happens next, or may, something that happens later on may have been ruled out because of what was decided. So that's why it wasn't, it was kind of fun, but it wasn't really an easy, like, oh, here's the best process. There is no best process. It's all dependent.
So we'll definitely give you some more fun tasks. But I want to propose one thing to the board. We have 2 board members that are missing. Is this something we want to vote on today? Or if we're just going to go line item by line item, do we want to give them an ability to have their say on it or their vote?
I think since we don't have any elections coming up, they can definitely have a say. But I also think that since it's here, and it would decrease the amount of discussion for later, because those 2 board members could think about what we said, we should talk about our options.
Narrow it down.
Well,
Yeah,
not
'cause
not
those
even
board-
narrow it down, because they need to have their say, but I think it would help if we talked about this now. And not necessarily made a decision, but I think start the discussion, and then we can bring it back and the other board members can talk about it as well.
Well, that's what I was
Yeah,
trying to avoid. I'm sorry.
May I just ask, what's the urgency? I mean, in the spirit of time, in the spirit of 2 member missing, this is not like urgent.
Requested to be on, it's not urgent, but the reason it's here is because it was requested to be on this agenda of this board.
Yeah, what I was suggesting was I was trying to avoid us having a lengthy discussion now and then having the other 2 members not privy to the discussion, and then we're asking for a vote. So
No, we're not gonna ask for a vote. They would be privy to the discussion because those notes would be included in our next board meeting, and it would actually make the next discussion a little bit shorter if we could have some ideas for them to consider as well. Like, do we want to nominate for offices before any voting begins? Do we want nominations for each office? And then vote, and then nominate for the next office. I mean, I think having a discussion between us is a good idea because it gives them some guidance as well.
Well, I also want to throw something else in the mix, even though, I am, what Mr. Pulio was saying earlier, I think I agree. I think the more concise, the clearer, it would be better, but you could have the chair could appoint a nomination committee that would make recommendation, and then that would not preclude anyone that wanted to self-nominate themselves. But a nomination committee could make recommendation if you will.
But don't you
know.
think we have too few members for that? I mean,
Yes,
because
I
then-
do.
Then, I mean, who's gonna be on the committee?
It's gonna be all the people that are running, and I'm not sure that that would be a Begley Keene
I mean,
I mean, it would have to be a noticed meeting.
so.
Okay, I just want to, I'm sorry, this may influence, we have two board members who, the last flight to San Diego is 7:40. If we don't get them out of here on time, they're going to have to spend the night. So just want everybody to keep that in mind. But proceed.
So,
Well, I don't know how much conversation we need to have. If it were up to me, I would say we take line item by line item and just call for the vote. And then we can have the individual discussion. And since we don't have the two board members here, I would prefer to do that with them here. I feel like any conversations that we're going to have here may be circular. And we're gonna have to have them again when it comes for the vote.
do we need any kind of action on that, Ken?
You can move to table the item till the next regular board meeting.
I move this item to the next regular board meeting.
I'll second it.
Discussion? Call for the vote?
Dane,
Public comment, I apologize. No public comment, okay, call for the vote.
Dane,
Yes,
Lickman,
Yes.
Aslino, yes. Rufino.
Yes,
okay. Next item are the three bills that our committee talked about. The first one is SB 1480. This is our fee bill. And you can see in the materials that the recommendation is to support this. Do we make a motion?
Yeah, you
Yeah.
can make a motion to support and then you can vote if anybody has questions or wants to discuss.
I'll make a motion to support.
Second.
Discussion? Public comment? Call for the vote?
Dane,
Yes?
Lickman,
Yes.
Aslino, yes. Rufino.
yes,
So the next bill is SB 1448, also by Senator Hill. This is something that came around in the past and is coming around again that we have been in favor of. And it is about, well, you guys read it because it was in the packet, but it's about probationers divulging their probation status.
And this is something that the board last year voted to support,
Yes.
all the members who were here. Sorry.
It was 2 years ago.
Oh, okay. Details. All these members were in support previously, so just if it helps you with
I'll
your
make a
decision.
motion to support.
I'll second. Any discussion? Any public comment? Call for the vote?
Dane,
Yes?
Lickman,
Yes.
Aslino, yes. And Rufino.
Yes.
yes,
Okay. And then the final one is AB 2138, and it was in your packet.
I'll briefly give you an
please.
overview. We're recommending a watch position at this time. This is a very complicated issue because it deals with creating barriers, or it's trying to prevent barriers to people entering licensed professions, in particular individuals who've been incarcerated in the past and being able to rehabilitate and enter professions. There's a perception among some groups that the boards are turning away otherwise qualified individuals because of mistakes they made in their youth or in their past. The vast majority of boards disagree that, we think that the process is currently very fair and for vetting these, and if somebody has prior convictions, of making a fair determination about whether those are substantially related to the practice and should be considered in granting or denying the license. So the author's office is very sensitive to the concerns of the board. Not our board, but they have had meetings with all of the boards which we've participated in. They're sensitive to the concerns. They're currently working with the boards to try to address the concerns. So the bill that's in print right now will be changing. So at this point, I'm recommending that the board continue to watch this and work with the author's office to make sure they understand our concerns.
I'll make a motion to watch this.
second,
Any discussion? Any public comment? Call for the vote?
Nazalino, yes. Stain?
Yes.
Lickman?
Yes.
Rufino?
Yes.
Okay. So next is agenda item 17. Marcus, update, discussion, and possible action on pending rulemaking.
I'll keep it brief. We haven't had any updates. However, our application regulation, it's close to the 30-day, over the 30-day deadline for OAL to render an approval or disapproval. Just so you guys know, this afternoon I was contacted by our OAL attorney and he requested documents. So I would assume that probably in the next couple of days, he's going to inform us whether or not that regulation was approved.
Did he give a hint? Did he seem
No.
inclined to? Oh,
No, not at all. So.
And the CPEI
So
is
the,
still with DCA?
so
microphones.
Oh, I'm so sorry. The CPEI is still with DCA?
So, CPEI and the delegation of authority have been submitted to legal counsel, and we've been working through this application regulation. So those other haven't become a priority. So once this is gone through, whether we get the approval or disapproval for the application, then we'll be able to make some progress on the rest of the regulations. And that may not make sense, but there are a lot of changes that, should this be approved, that will require changes to the CPI regulation and also to uniform standards and things like that.
Got it.
So it will be premature for us to make significant process on the other regulations without knowing whether or not this application was approved.
So if this application is approved, or if it's not approved and it needs changes made to it, it's gonna make changes to the regulations down the line, which is why they're not being worked on while this thing is just sitting there.
Well, we finished
that-
the initial drafting of those regulations.
Yeah.
and they're
Okay.
sitting, they've already been submitted to legal.
And we do have, because we have, as we had announced previously, we have a retired annuitant that we have working, and she's currently working on regs and doing prep work for regulations. Also, another thing, the policy analyst position is currently vacant, so Marcus is wearing two hats right now because he's the assistant executive officer and trying to fill in the void there. We hope to have that position filled soon and have that person working more actively on all of the regs. So we're doing what we can on all of the regs, but the process is moving slow.
I guess what I meant to ask is, the outcome of the application for licensure may affect the
Yes.
uniform standards?
Yes.
Okay, that's what all right. Okay.
I actually want to congratulate you. We got the email, when you sent to us was that, remember this, that we went through all that were moved
yeah.
forward?
Congratulate
Yeah.
for what?
Well, I mean, for successfully
yeah.
getting,
Yeah, I think I'd let you guys know that I finally submitted it.
Just say thank you and take it.
never mind, it's 6
I
o'clock.
appreciate it. Thank you.
Great job.
Thank you, Marcus.
You're the best.
Next is closed session, but because can we ask for public comment for items not on the agenda before we go into closed session? So we'll ask for public comment for items not on the agenda. None? And we'll ask for future agenda items. No?
Yeah, I have a couple.
Okay. Mr. Phoenix?
So the first item that I like for us to put on the agenda, I'm not sure if it needs to be agendized, but I'd like to hear about, there is two legislation. One is the Louisiana House Bill 748 and 372 that that deals with the term certification and so on and so forth, and limiting that sort of certification and who can use it and who cannot. I'm not sure if there's any relevance to us, but I thought it would be a good idea to understand and to see whether there's anything that we can learn from these bills. So two of them are in the state of Louisiana, and they did pass their House, and one is in the state of Missouri, which limits, the ability, and that's House Bill 1500. So there's no rush, but I was gonna just send a simple email, but now I'm kind of like want to make sure that I do this in public, and so if it needs to be agendized, then let's put in there. If does not need, just to get a report whether it's relevant or not to us.
Can you send it to Robert, or can staff pull that up and get that to us so that we can?
Sorry, but I got distracted for a minute, so I didn't hear exactly what bills you were referring to.
So
Here in
there's
Louisiana?
there's two in the state house in Louisiana that actually cleared the assembly.
What are they related to?
Certification, they're using the term certification, whether they can use these, the certify for certain specialties.
Is that
Are
specific
they
to medicine
general
or?
Yes, oh yeah, specific to medicine, yeah,
Medicine,
yeah,
healthcare?
yeah. And the second one is a bill in Missouri which limits, when you can put on after your tire, that you can limit the advertisement and so on, and that's House Bill 1500. So,
HB 1500.
for the state of Missouri, is awaiting the governor's signature. I'm not sure if it's gonna get signed or not, but it's irrelevant. I just like to see the text and whether there's anything we can learn from those bills.
And then do you know the numbers?
Yes, I do. The Missouri one is House Bill 1500. The Louisiana bill, or House Bill 748, excuse me, and House Bill 372.
Okay, that's all I need. I'll provide information about those bills.
And then you had another concern about sending the request through email that I didn't quite understand.
Well,
We're gonna send it through email, but
yeah, I just I figure this is possibly the better forum. The other request that I have is, this is a full blown, I know this needs to be agendized, and that is establishing a special committee of the board to open the Chiropractic Act of 1922. This one possibly needs to be agendized, I'm not sure, but it's been also other board member have mentioned, specifically Dr. McLean at the last meeting about getting board agenda materials, and if you go back to the minutes, you will, there's, captures some of that discussion, but I'm not sure, and I understand there's some reports, that they cannot be prepared way ahead of time, and we have to wait like financial reports or some other things. But there's some stuff that I think could be provided to the board way in advance. To provide something to the board the night of, at 7:30, 8 o'clock at night, and the next day you're gonna be dealing with those, it is, we all assume that we are awake. We all assume that we can look at the stuff. We all assume that our phone is working. We all assume that we have the time. I mean, I just think if there's a way for us to come up with some suggestions, like the board agenda materials perhaps should be arriving 15 working days prior to the board meeting. I don't think, and I was gonna say 30, but just to give maximum flexibility, I don't know.
Mr. Griffin, we'll have to discuss this, but because of the 10-day notification of the meeting, that would be sending out materials prior to knowing what's even going to be on the agenda. So there's
maybe 5
complications
days.
with that. Yeah, and I'm not,
Yeah.
and typically we try to send the materials out a week before. That's,
So let's put it on the agenda, and then we can talk about it. We can explore what all the, limitations and so on and so forth. Perhaps it could be 5 days, but being 2 days before, it's kind of cutting in, especially if there's a technical issues. For example, I experienced a technical issue with my board packet this weekend. It was required for me to sign it. I was not there. So to begin with, it arrived on Friday. The board meeting is on Tuesday. if I'm leaving out of town or if I'm not in town. I mean, it just makes it a little bit difficult.
I understand that, and because we're
But
not
no
talking
big
about
deal.
policy, I just want to explain a little bit. Staff don't like Tuesday meetings because of that, because with the weekend, it doesn't give us time. In this, this current meeting, we actually weren't able to schedule two of the committee meetings until Thursday and Friday of this past week, and then having the meeting on a Tuesday. So that prevented us from getting materials related to those committees, which there was a lot of information, much sooner than the day before the meeting. So we do our best if it's something that's readily available to get it out very quickly, but then there's some things that just aren't possible.
I get it. That's why I sort of wanted to agendize so that we can kind of take a look and understand those things so that we know, the board knows that if you're scheduling a meeting on Tuesday, you're going to run into this problem. So that way we can be more responsible. And the other thing is with minutes, same thing with the minutes. There's no reason why we should not have 30 days after the board meeting, at max. We should not have a draft of the minutes rather than wait until again, 2 days before. So that gives you a little more time to read and plus your memory is better and so on and so forth. So I don't know if these rise to agenda or it can be addressed in another matter, whatever works.
That's up to the board.
The other thing we always had, and I got the answer now because on some of the committee compositions and the chair, some of them did not reflect who was the chair, but today was clarified, who the chairs were. But if we can have a roster, and I'd like to request that I be added to the committee, to the Government Affairs Committee, not as the chair. I do not wish to be the chair, but just as a member. But if we can get in the past, I think we have published, the roster so everybody, we could see who's the chair, and that would be, I think, useful for all of us to know. And that's all. Thank you.